All right. Good morning, everyone. Welcome to the first in-person meeting of the California Cannabis Advisory Committee. It's really nice to meet a lot of you in person finally. We have a new member. September 7th meeting is now called to order. We have a new member, Dr. Michael Paulson, with us today. Welcome. Dr. Paulson is a social anthropologist at the University of California, Berkeley, where he's the co-founder and incoming director of the Cannabis Research Center. Dr. Paulson has been conducting research in cannabis since 2010. His research broadly revolves around the transition out of the war on drugs and into legality, with a focus on cultivation, farmer livelihoods, community and ecological dynamics, and policy. He's currently conducting several studies with the support from the DCC and on local policies, unlicensed cultivation, cultivator communities, and anti-competitive industry practices. He publishes his journals across the social sciences and has been supported by institutions like the National Institute of Health, National Science Foundation, amongst others. Welcome. Really look forward to working with you. Moderator, can you please take roll call?
Of course, but before we begin today, I'd like to make a note about our meeting format. The Bagley-Keene Open Meeting Act exemptions expired in July of this year, so our Cannabis Advisory Committee meetings, as Chair Jamalian said, are now conducted in a hybrid format. This means that we have attendees both in person here at DCC headquarters in Rancho Cordova and virtually over WebEx. This is our first week of hybrid meetings, and the DCC team has worked really hard to ensure a seamless transition into this new format. The most important part of these meetings is public input. That's why we're here. So if we run into any technical glitches, which we have not, knock on wood, so far this week, please know that we'll work them out and you will be heard. So just keep raising your hand. And with that, we will start the roll call. Member Bauer? Dr. Brown? Member Brown? Member Christensen?
Present.
Member Clifford? Member De La Rosa? Member Frazier?
Present.
Member Iamoto? Member Pan Pearson? Member Paulson?
Present.
Member Shockley?
Present.
Member Tupy? Member Woolsey?
Present.
Vice Chair Nevedal?
Present.
And Chair Jamalian.
Present.
Okay, we do have a quorum.
Thank you, moderator. Item 2 on the agenda is the review and approval of the March CAC meeting minutes. Members, if you have any comments or discussion points, please feel free. Otherwise, we'll make a motion to adopt them as they are.
I'll make a motion to adopt both the March and I believe July meeting minutes as they are.
Thank you. With that, could we open up for public comment, please?
Okay, we are now taking public comment on agenda item number 2. The topic for this public is approval of the March 9th CAC meeting minutes listed on the screen. If you would like to make a comment, please raise your hand by clicking on the hand icon next to your name if you've logged in to the meeting, or pressing 3 if you've called in. For our in-person commentators, please raise your hand and our audience moderator will work with you. When it's your turn to speak, you may choose to state your name, but you are not obligated to do so. And all commenters will have 2 minutes to speak with a 30-minute warning. And please keep each comment period focused on this agenda item. So with that, please raise your hand if you have any questions on the minutes. Does anyone have comments on agenda item number 2? Chair Jamalian, I see no requests for comment. Would you like to close public comment?
Yes, please.
All right, public comment for agenda item number 2 is now closed.
Can we get a vote on the motion?
Yes. Member Bauer? Dr. Brown? Member Brown? Member Christensen? Member Clifford, not here. Member De La Rosa?
I'm okay. Yes.
Member Frazier?
Yes.
Member Iamoto? Not here. Member Pan Pearson? Not here. Member Paulson?
Aye.
Member Shockley?
Yes.
Member Tupy? Member Woolsey?
Aye.
Vice Chair Nevedal? And Chairman Jamalian.
Aye.
All right, the motion passes.
I'd like to point out that we passed the motion for March and June minutes, so we can go on to agenda item number 4, public items, public comments on items not on the agenda. So if we could open up for public comment, please.
You bet. We are now taking public comment on agenda item number 4. The topic for this is listed on the screen. It's items not on the agenda. And again, I'll reiterate quickly, if you'd like to make a comment, raise your hand by clicking on the hand icon next to your name if you've logged in, or by pressing 3 if you've called in. For our in-person commenters, please raise your hand and our audience moderator will work with you. And when it's your turn to speak, you may choose to state your name, but you are not obligated to do so. All commenters will have 2 minutes to speak with a 30-minute warning. And with that, we will go to our first commenter online, which is Sasha. I've sent you a request to unmute.
I'm a cannabis delivery retail owner, and one thing that has come up that I noticed is a bit unfair, and I was hoping that this could make its way to the finance team, is that the cost to renew a retail non-storefront delivery license is the same that it costs to renew a retail storefront. And anybody who's in finance or knows a P&L or books knows that the cost to run a delivery is much more burdensome and heavy on the bottom line, between all the insurances, the cars, mandating security within the cars, et cetera, you understand. I'd love to get this topic put on some sort of motion or bill, or a readjustment in the fees, because we're talking 20% probably in a net profit difference when you look at this. And, with businesses mostly being above $1 million in revenue, we're talking a lot of money, and you guys charge a lot for the renewal fee. So that's my request. I really hope somebody from the finance team can take a look at that. It's pretty black and white. Yep. It's a no-brainer when you look at it and you compare 2 similar companies doing the same revenue from one side to the other. Thank you.
Thank you. All right, we have an in-person commenter.
Good morning, everybody. My name is Cesar Casamayor. I'm the co-founder of the People's Fresno, part of the People's Ecosystem. Apologize for yesterday giving a long spiel, but the point is this. Assemblyman Joan Sawyer's successful request for a joint legislative audit committee to look into cannabis licensing practices at the local level, highlighted in a LA Times piece, corruption is widespread in California's weed industry. We are a social equity applicants. We agree with Assemblyman Jim Patterson's comment to the Los Angeles Times saying that Fresno should be included in citing the undercurrent misconduct here in the 5th most populous city of California. Undercurrent is a good word for it, but what Patterson characterizes as a misconduct is regarded by those involved in business as usual in Fresno, leveraging personal, professional, political relationships for their interests. We have met with Eugene Hillman back in March. We have spoken with Ms. Fiona Lavelle from GoBiz, and still they cannot hold accountable municipalities that receive social equity funding with poor accountability measures. We've experienced and worked within the scope of our city's policy and practice, but they don't ensure fairness, nor do they prevent conflict of interest, predatory practices, and favoritism. Prompted by Assemblyman Joan Sawyer's positive action on May 10th, we submitted a following op-ed for the paper. They didn't bill it. What we need the state to step in and conduct a full audit of Fresno's cannabis policy and roll out of regulation. The policy fixes must come from Sacramento, specifically the Borough of Cannabis Control, the Joint Legislative Committee, and Attorney General Bonta's office. Thank you for your consideration.
Thank you. E. Walker, 323, I've sent you a request to unmute.
And a youth mentor, and I try to keep up with every report, every article, every peer-reviewed article I can on cannabis. And my biggest concern is the high potency. I've read a lot coming out of Colorado And I'm just very concerned that we are not doing enough in terms of considering potency caps. I would really like this, I would really like for you to consider potency caps. I wonder why when in Europe 10% THC is considered a hard drug, why we allow such high concentrations in the United States. I think it's really a critical issue that we need to address and would like to see you put a greater focus on it. Thank you very much.
Thank you. Kelly McCormick, I've sent you a request to unmute.
I'm a public health educator who works with youth. And as the previous caller said, there is a real need for warning labels regarding the mental health effects of high THC cannabis products, because there is ample evidence of mental health effects. And that's on youth, but also up to age 25. So the brain is still developing until 25. And it's important because parents and many young people don't know what the mental health implications are of high THC products. And we're seeing an uptick in the number of youth, again, under 25, who are using on a daily basis these high potency products. And so there's a real need for warning labels and more education. Thank you.
Thank you. Joanna, I've just sent you a request to unmute. Joanna? Oops. There you go. Try again.
Can you hear me?
Yes.
Great, thank you. If this committee is going to be successful advancing public health and safety, then it needs to recognize that intoxicating cannabinoids are such regardless of source and need to regulate according to that goal. This means that intoxicating hemp that is available without age gating throughout the state and in concentrations that far exceed those in the regulated marketplace need to be addressed. A few of the commenters have already mentioned high potency products and the desire for caps. Those will be wholly unsuccessful if they do not include hemp as well. Cannabinoids are cannabinoids, regardless of source. Thank you.
Thank you. Are there any more commenters on this agenda item? Oh, we have one in person.
Hello, my name is Christian. I'm a general manager of a dispensary in Santa Rosa. And I guess my question today is around purchasing limits and basically the recreational versus the medicinal. I don't know if I have a full understanding of the reasoning behind it, and I think it could be for safety issues and things like that, or possibly reselling. But what I find is, even if there's something with reselling, everything that goes through the legal cannabis market has been tested and taxed as well. So kind of better going through the legal market than capping people in the recreational, and then they just go to the black market, quite frankly, and buy as much as they want, which is not lab tested. And I started out in lab testing. I know you're all familiar with the myclobutanol epidemic and things like this. And those are still going on, obviously, in the black market. So I find if we allow recreational users to purchase more, it'll actually probably be safer for the public as a whole, even if they're turning around and selling it again, which isn't ideal. But better that person that is selling lab tested, clean, safe marijuana than the person who's in the black market and just frankly doesn't care. And then on top of it, in regards to kind of defending kids and whatnot, you know, we get a lot of 18-year-olds and they're only allowed in the dispensary with a recreational, or excuse me, with a medicinal recommendation. And of course, they can just purchase way more than the average recreational user who's 21 plus. So it's kind of a weird matchup. It's really all. Thank you.
Thank you. Jay Johnson, I've just sent you a request to unmute.
Thank you for having my call in today. Wanted to address the elephant in the room with the council today, and that is with taxes. I didn't see it as an agenda item, but it is the biggest hurdle facing the community and the cannabis industry as a whole here in California. If you look at license renewals in the state, especially in my city here in Sacramento, where I am a license holder and a graduate of the equity program from Sacramento, the hugest obstacle is taxes. It's a weight on our shoulders, it's a weight around our ankles, and it's dragging the industry down. I know Senator Bradford out of Southern California has made proposals to give tax relief to cannabis businesses, and I think it needs to be at the forefront of issues, because what's going to end up happening, and we're already seeing it with license renewals, is all of the all of the talent that California has produced over the years, with this being one of its largest cash crops, is leaving California and going to other states that are opening up with cannabis. There is no reason in my mind that a state such as Missouri should be passing up legacy states with sales. But the reason why they are, one of the largest reasons, is they have a better tax code than we have out here for California. We have 3 different taxes that are imposed on a product before it meets the consumer. I don't even know how that's possible. Sometimes there's 4, depending on how it's packaged and manufactured. So I would hope that we could talk about that today, or maybe you guys could put it on your agenda for the next meeting. But we need to address the taxes in the
30
state,
seconds.
or you guys are going to start losing more of your legacy farms, your legacy brands, and your legacy operators in the state. It should have been a canary in the coal mine when all the MSOs, multi-state operators, have just chosen to leave the state of California because it's impossible, damn near unsustainable, to do business here with the way the taxes are. So please keep that on your mental today as you go through this meeting. Thank you.
Thank you.
Thank you.
Kimberly Cargile, I've just sent you a request to unmute.
Join us at this meeting today. My name is Kimberly Cargile, owner of a therapeutic alternative and many other businesses, cannabis licensed businesses here in California. I am here today to speak on behalf of the consumers. And I know that we're not talking about changes to the regulations today, but this is something that I submit every time there is a change to the regulation, is a request to have terpenes listed on packaging. Terpenes are active ingredients, just like cannabinoids are, and they cause pharmacological effects on the body. When a patient or when a member wants to know the difference between a strain or a cultivar or a chemovar, those are based specifically on terpenes. The terpenes are what make the cannabis smell different and also make it feel different. And right now, consumers are not having access to that information, and they should. Also, terpenes can be toxic. They actually have lower levels of toxicity than cannabinoids do. And consumers have a right to know the exact levels that are in the cannabis, especially since many companies are adding terpenes back in, and we don't know what levels they're adding them in at. So I think that we really need to put this on the agenda to incorporate terpenes into required labeling for the regulations and for consumer protections and consumer rights. Thank you so much.
Thank you. All right, I don't see any further commenters either online or in person.
Thank you. That concludes agenda item number 4. And I just want to remind my fellow members, we're not allowed to engage with public comment. We just take it, and then what we do with it might end up on the next agenda or not. Sorry, Doc. I agree with you. Or legacy. Yeah, I agree with you 100%, but we're still not allowed to engage with them. But thank you for bringing that up. Moving on to agenda item number 5, labor peace agreements for the cannabis industry. It's a pretty hot topic at the moment. We're very, very lucky to have Ed Blanco from the Agricultural Labor Relations Board and Matt Broad, legislative advocate for the California Teamsters Public Affairs Council here. Thank you for being here. We look forward to your presentation.
Can you hear me? Okay. Thank you. My name is Victoria Hasid. I'm the chair of the Agricultural Labor Relations Board, and I'll also be joined here by Ed as well. Very appreciative of the opportunity to address the council today and provide this presentation. I did send a PowerPoint ahead of time if that can be brought. Oh, there it is. Thank you. So our primary charge is to administer and oversee the Agricultural Labor Relations Act. That's been our charge for nearly 50 years, since 1975. And while it is a labor management rights statute, its core is that it's a worker protection statute. It's whether workers want to join a union. If they don't want to join a union, they are protected regardless of if they're a union or not when they come together and advocate for themselves for better working conditions, whether that be an increase in pay, a health and safety issue, or simply how they're being treated at work. And so that's our primary goal. But as a public servant, one thing that I strongly believe in, and is particularly as someone who has a regulatory and enforcement role in the cannabis industry space, as well as any other industry, is that we have a duty, if the state has standards, to ensure that the regulated community knows what those standards are, understands how to meet those standards, and comply with them. I firmly believe that protecting your workforce and investing in your workforce leads to a thriving industry, and that thriving industries invest in that workforce. So that's my core tenets. A little bit about myself. I've been at the board for 3 years. Prior to that, I've spent over a decade working in state labor and employment roles, primarily the Department of Industrial Relations, overseeing Labor Commissioner's Office, Cal OSHA, and workers' compensation and apprenticeship. So I have a long background in administrative enforcement schemes that help protect workers and that regulate licensees and employers. And I will, just for a little housekeeping, I will be going over the ALRA and how our organization works, but the bulk of this presentation and where I'm really hoping to engage in a dialogue with CAC and others is on our new authority under the Business and Professions Code that was enacted last year to receive and investigate complaints regarding non-bona fide labor organizations that are parties to labor peace agreements. I know there's been a lot of buzz this summer with our first received complaint and then our decision that came out in Professional Technical Union 33. So I will be going over some of our agricultural focused responsibilities, but really hoping to spend the bulk of our time talking about the LPAs, because I know that's of great interest to everyone here. And with that, I would like to introduce my colleague, Ed Blanco, and have him tell you a little bit about himself.
Second the chair. As you heard, my name is Ed Blanco. I am an attorney with the Agricultural Labor Relations Board. I joined the board in 1980, so I'm going on over 40 years with the board. The last 7 was tasked, over the last 7 years, I've been tasked to be the point person for our agency to the cannabis cultivator and trimmer community to lead our outreach and education efforts. So that also meant speaking with cannabis employees, the HR professionals that represent the employers in that relationship with employees, and also the attorneys that represent cannabis employers like those who are members of the INCBA. I've spoken at a lot of cannabis conferences, regional associations like CBCAN, and also to small groups of cultivators like up in the Triangle area. Currently, I'm working on a project with local jurisdictions that license cannabis industry to focus more in detail on LPA situation. So right now I've lined up San Jose, San Francisco, Oakland, Palm Springs, Desert Hot Springs as partners in that effort to do that with their particular licensees, trying to line up other jurisdictions as well to do that. And when we get dates and times for those events, I will be sharing them with DCC so that they can put that on their website and let everybody know about it. And look forward to speaking with you a little later.
Thank you, Ed. We're very lucky to have you still with the ALRB. Huge wealth of institutional knowledge. Next slide, please. I want to ground our conversation today in California's commitment to labor rights. We just celebrated or honored the Labor Day holiday, and also on August 26th, the 3rd California Farm Worker Appreciation Day. As you well know, California has a strong and long history of protecting workers and honoring labor. And there are several worker protection statutes unique to cannabis that I want to highlight. One that you're all familiar with and that we're going to be talking about a lot today is the requirement currently that licensees, regardless of what industry they're in, who have 20 or more employees, have a labor peace agreement with a bona fide union. That threshold will lower to 10 as of July 1, 2024. And we're going to spend the bulk of our time talking about those requirements today and some of our initial decision that we issued earlier this month or earlier this summer. California also requires that one supervisor and one employee have completed the Cal OSHA 30-hour general industry training course provided by an authorized OSHA Training Institute Education Center. This is a unique requirement. I was at the Department of Industrial Relations when this passed. And the thought was, because this is an emerging industry and everyone is new to working in this regulated environment, it would be helpful to have ensure that there were employees that also were aware of these safety requirements. Cal OSHA also had a special advisory committee several years ago to discuss the need for cannabis-specific occupational health and safety rules. California may have instituted the first cannabis-specific LPA requirement, but we are not the last. Several other states have enacted this requirement, including New York, New Jersey, and Virginia. And we've seen other states look to expand this requirement, including those in Maryland and Massachusetts. The administration has engaged in numerous efforts to help combat the underground cannabis industry and increase oversight and information sharing between agencies to protect workers. And we look forward to continuing to participating in a variety of forums and task force in order to help support workers in the industry. I included a quote, which is very hard to read on this, but I will read it to you from our decision in Professional Technical Union Local 33, which in my view gets really to the heart of what the board is looking at when we are looking at whether an organization is bona fide or not. When the ALRB makes a determination about whether a union is bona fide, we are not about policing unions, but about ensuring workers in an emerging industry have access and obtainable means to learn of and exercise their labor rights if they choose to do so. The real harm of sham labor peace agreements isn't giving legitimacy to a non-bona fide labor organization. It is depriving workers that may be particularly vulnerable to exploitative practices of their right to be, at minimum, aware of their employment rights. And in my view, this really gets to the heart of this process. Next slide, please. So as mentioned, our primary role is over farm workers and administering the Agricultural Labor Relations Act. Farm workers and agriculture and domestic workers were excluded from National Labor Relations Act protections in 1935. After years of organizing, California was the first state to enact an Agricultural Labor Relations Act. There are about 16 other states that now extend a version of this protection, but I believe we're still the only state with a full agency that oversees such protections. So this is particularly relevant for the cultivation licensees that are on the council or watching the meeting. And essentially what the act does, I've listed sort of the core principles, but we protect the right of employees to come together, work for mutual aid and protection on behalf of the collective. So this is not necessarily about one employee who has one pay stub issue or something like that. However, it's when they're working on behalf of the crew. Now, there have been examples sometimes where workers have experienced harassment, and that can be found to be a collective violation. It's when the act's protections are triggered when workers exercise these rights, and then the employer retaliates against them for exercising those rights. That's the core tenet. We also provide collective bargaining rights. However, as noted, the act still applies regardless of whether employees are in a union, and we have election procedures, which I'll detail as there's been major changes in that area as well. Next slide, please. So the board is composed of 5 members. We're a quasi-judicial agency. We are all appointed by the governor to staggered terms. We're responsible for general oversight of the agency. We make fact-finding decisions and have authority over administrative adjudications. We defend the agency in court and promulgate regulations. We do have regulations that are in the final stages of the process. I believe tentatively, if OAL approves, should be ready by January 1 that govern the labor peace agreement complaint process. And those materials, if you want to see the draft regulations, they are posted on our website. And we also hold public meetings every other Wednesday and frequently discuss topics of interest to generally the farm worker community. Several years ago, right before the pandemic, we had an event in Cathedral City discussing the cannabis industry, and I hope to have another event like that soon. Next slide, please. Our agency is really in two primary parts. So we have the board, and then there's the general counsel. The general counsel is also appointed by the governor. As they receive charges from agricultural workers, they then investigate those charges, and if meritorious, will issue a complaint, which essentially sets an administrative hearing. We have two regions, the Salinas region, which has offices in Santa Rosa, Salinas, and Oxnard. So basically west of I-5, and then the Visalia region, which has offices in Visalia and Indio, so east of I-5. And then we have our headquarters here in Sacramento. The general counsel can also seek injunctive relief if there is a severe incident with a worker requiring that the employer reinstate that worker immediately. Next slide, please. So our primary bread and butter is unfair labor practices and elections. And again, I just want to signal this is really applicable to our cannabis licensees. Other licensees that may have labor issues, they are governed by the National Labor Relations Act. There could be instances where there may be a jurisdictional issue determining whether a worker is really a cultivator or falls outside of agriculture, but that's something we anticipate seeing more in the coming years. So unfair labor practices can be filed by employees, by employers, labor organizations, community-based organizations, et cetera, against either an employer or a labor organization. You have 6 months from the date of the unfair labor practice, so when the adverse action happened. And some examples include retaliating against workers for striking for higher pay, a union threatening worker for their support, and retaliating against worker for participating in a labor investigation. The general counsel investigates, and if meritorious, files a complaint, and hearings go before an administrative law judge. Appeals from those, and almost all of our decisions do get appealed, go up to the board, and if they're appealed further, they go to state or federal courts of appeal. Additionally, the majority of our cases overall, of the charges, I should say, they do settle. I don't have the exact rate, but I would say it's probably 80 to 85%, and they're negotiated settlements with workers. We also hold elections. There are now, as of legislation last year, 2 paths to a workforce selecting a certified bargaining representative. One is the secret ballot election, where similar to NLRB elections, there is an election. The workers have to have a minimum showing of interest. Under our lots, 50%. That's higher than under the National Labor Relations Act. If that is found to be sufficient, there'll be an election at the work site, and a majority of the voters determines if there is a union has been selected. The new process is the majority support petition process, which is colloquially known as card check. And this requires workers to sign authorization cards or petitions, and it's only available to certain unions that meet requirements. Okay, next slide, please. Another big component of the bill that added this new election process is civil penalties. This is a huge new area and one that we are trying to educate employers about. Again, this will only apply to those cultivation employers here. These penalties are modeled after a penalty scheme that was proposed in the PRO Act at the federal level to apply to the National Labor Relations Board. That act has not passed, but California did pass the civil penalty provisions. These can result in fines of anywhere from $10,000 to $25,000 for employers per violation as described. So something to definitely be aware of. We have not assessed any penalties as of this point, but I assume as more cases come before us, this will be coming up. Next slide, please. Now to, I think, the area where everyone cares about, our authority under the Medicinal and Adult Use Cannabis Regulation and Safety Act. So as you are well aware, we discussed the LPA requirements before and that there were changes made by AB 195 last year, lowering the threshold, but more relevant for us, allowing us to receive complaints from either current or former employees or unions alleging that a licensee is a party to a labor peace agreement with a non-bona fide labor organization. We have, this is not limited to just the cultivation licensee. So this is across industries, which is a unique authority for us. And ALRB has 90 days to issue a report, what we've called the decision, to the Department of Cannabis Control, who from that point forward can take action on a licensee. Next slide, please. This slide and this PowerPoint can be shared with anyone. Includes several examples of the definition for a labor organization. So there is a definition under the National Labor Relations Act as well as our act. We use a lot of the same terminology, except our act specifies this only applies to organizations involving agriculture. The NLRB, and there's case law under both of our bodies interpreting this term even prior to the statute. And the NLRB has interpreted the term broadly to mean any organization where employees participate for purposes, at least in part, of dealing with employers concerning grievances, labor disputes, and other terms and conditions of employment. Next slide, please. So far, the ALRB has only issued one decision. We did receive our second complaint a little over a month ago. The first decision is in Professional Technical Union, Local 33. That is available on our website. And in that decision, we are dealing with a lot of novel issues. We had signaled this in our administrative order. One thing that we were mindful of, and that many of you have seen probably just as members of the general public, is we did not want to foreclose opportunities if there was possibly a startup union. So when you see the actions going on in, say, Starbucks or Trader Joe's, those are startup kind of worker grassroots created unions. And we wanted to make sure that as we evaluated these complaints, we weren't foreclosing that possibility while also being mindful of, we wanted to ensure that these were actual labor organizations intending to deal with workers that they could actively participate in, even if maybe they didn't have all of the structure set up as some of the older, more established labor organizations have. So we outlined in our decision that for purposes of determining whether a labor organization is bona fide under MCRSA, that's how I say it. I'm curious how you guys say it. The ALRB has identified two factors that it may consider: that labor organizations cannot be employer sponsored or dominated. And this is something that's deeply rooted in our act out of a history with organizing in the agricultural space. And there must be evidence of sincere, good faith intent to organize and represent employees as a collective bargaining representative, including capacity and ability to do so. So some critical factors that we discussed were accessibility and ability for workers to find the labor organization and work with them. Does the labor organization have a website? Do they have a presence here in California? Do people know how to contact them? Does the organization represent other workers, whether in or out of the cannabis space? Have they tried to organize other workplaces? And do they have a structure? Are there offices, elections, or bylaws? These aren't determinative factors, but they're indicative of proving whether you're a bona fide labor organization. Next slide, please. Here was some other information that was really critical. One of the things, if you read the decision, the board made a point to say that those that are being investigated need to be cooperative. This doesn't mean you need to provide you have to have your legal strategy that's adverse to your interests. But the ALRB, when they request information, particularly if we request information that should be publicly available, that failure to provide that can result in adverse inferences. We also ask that licensees that sign the agreement with this organization participate in this process. And this is particularly relevant for you. For us, and the board commented on this in the decision, the Professional Technical Union 33 had LPAs with several licensees, including one in particular that was listed in the complaint. And that licensee was completely silent during this process. And I believe has actually closed up shop. And so that was indicative that maybe this was something that they didn't want other people to know about, this agreement. In terms of the process, once the ALRB issues a decision finding the labor organization is not bona fide, DCC can then take action on that licensee. And we saw that DCC acted swiftly in this case. They issued, I believe, an unprecedented bulletin to all licensees advising them of this issue, and then issued notices to comply with those licensees with LPAs with ProTech. requiring them to obtain a new LPA with a bona fide labor organization within a defined time period. As I mentioned, our regulations governing this process are pending with the Office of Administrative Law. I understand the department will also be updating regulations to implement AB 195. And I'm so appreciative of their invitation to us to provide feedback and input. Some of the things that we've discussed, they've already done. I really want to commend the department for providing the transparent database that shows which licensees have LPAs and with whom. I think that's really valuable for everyone. And I can only imagine what a Herculean effort that is as someone who's dealt with developing state databases. There are also some resources that I want to highlight for licensees. I think the department did a great job with their frequently asked questions, and that can be found on their website. And if this is shared after, it's hyperlinked in this PowerPoint. I have also included links for our decisions and administrative orders. We now have 2 administrative orders relating to LPA complaints, one in professional technical union and one that we issued last week or the week before last in the complaint by the brought against the National Agricultural Workers Union. I can't otherwise talk about that matters. It's being investigated, but you can see our order. And I also include a link again to that DCC website that provides the link to which licensees have labor peace agreements. And our last slide, this is contact information for each of our regional offices, as well as our headquarters office. And I included our executive secretary, Santiago Avila Gomez. He's kind of our clerk of the board, if you will. And so if there are cases that you're dealing with, whether it be a unfair labor practice case or a LPA complaint, that would be who you would go to. And I've also included Ed's contact information. And I would now like to invite Ed up, given his history of conducting outreach in this area. He can touch on some special issues that I didn't touch on in my presentation, and I'll be available for questions after.
Thank you.
Thank you, and hello again. So keeping the focus on LPAs and sort of giving a sneak peek at what my presentation is going to be like in more detail with the local jurisdictions. LPAs and our law cross in other ways as well. And it provides another layer of things employers cannot be doing when they're engaging with employees and unions, as those employees and unions talk to each other at the workplace under labor peace agreements. So I want to highlight some of these things for you here. Employers cannot reject LPA requests, especially when you've already signed one with a union. You cannot be saying to other unions that come to you, I've already signed one, we're one and done, that's it. There is no one and done with respect to the law. If other unions ask for an LPA agreement, you must give it to them, and it must be on the same terms as the union that got the first agreement from you. So a refusal to do that is potentially an unfair labor practice under a law. Now, with workplace organizing, as an employer, don't share your preferences with your employees. Don't tell them you like Union A over Union B, or you think that it would be a better fit for them if they were represented by Union A and not B. And don't tell them that you really like a certain union and would love to see them support it. Those are all things that are against the law. So you do not want to be doing that. Don't ask employees any questions about what they talk to about organizers or what they think about unions in general or those unions in particular. And don't ask them what they say amongst each others about unions. So basically, the topic of unions, once that organized, especially once the organizing starts, is really one that should be off limits for you as employers. Unionizing is meant to exclude the employer from that conversation. You cannot be a third wheel. There's no room for you in that relationship. It's just between your employees and the union. So best advice is to stay out of it. There are a lot of other potential ULPs, unfair labor practices I could talk about, but I think one that's I think very interesting, and it'll be the last one I touch on. That's called surveillance. So it's unlawful for employers to surveil their employees while they're talking to organizers or amongst themselves about unions at the workplace. And but this brings us in conflict, I think, with the cannabis law. As the cannabis law requires 24-hour security cameras on premises, and figuratively, if not literally, those cameras cover every inch of your property, meaning that wherever the employees are going to be meeting with union organizers is going to be, no doubt, on film. And under the law, historically, it has been unlawful for employers to take cameras, take pictures of their employees meeting with union organizers, or to take video cameras and film them while they're meeting with union organizers. So that is automatically an issue when they have these cameras all over the place on your properties. First, don't watch those videos of those workers meeting with your organizers, either in real time or in playback. Just stay away from that, because if somebody finds out about that, you could run into an unfair labor practice just on that basis alone. But it's, so it's hard, I think, for employees to, and organizers to be in the presence of those cameras and not think they're being watched. So that is something that's just there. I mean, that's an issue that won't be going away as long as the cameras and the law require them to be where they are and how they are 24 hours a day. But I think it's even harder for employees and union organizers to think that it would be mere coincidence if employees who attended these meetings were subsequently disciplined or fired, and not think that there was a connection between them attending that meeting and you knowing about it just by virtue of the video cameras. And I think that that inevitably would lead to unfair labor practice charges filed on that issue. And I think the best thing to say is to be prepared for that possibility by first having a company handbook with written policies that deal with disciplinary issues. Don't stray from those policies. Don't create new policies on the fly as that are not in your book as these organizing meetings take place, and then use that to fire employees or discipline them. Closely follow your written path of discipline. Don't speed up the process. Don't skip steps. If, for example, your policy contains the need for 3 warnings before you actually do discipline, don't do the first warning and then step over the other 2 steps and fire somebody right then and there. All of those would be clear signs that it wasn't a coincidence, that you actually did see or heard about the workers meeting with the union, and that you took action to send a message to all of your employees that if you meet with union organizers or you support a union, you will face discipline, you will be fired, and letting everyone else know that that's what's going to happen. The last thing I want to say about this is treat all employees the same. For instance, if you have 2 employees, one attended the meeting and one didn't, both violated your rules, and you didn't discipline the worker that did not attend that meeting, then I think you're going to find yourself in a situation that you're not going to be able to explain away convincingly why you disciplined the union member and the one that didn't attend the union meetings. Anyway, with that, I'll stop right there. I'll get, as I said, once I get these meetings going with the local jurisdictions, I'll get into more detail and more on a granular level about LPAs and approaches that may lead to other potential unfair labor practices. But anyway, thank you for your time. And again, we're available right now for questions if you have any.
Thank you. Yeah, the floor is open to my fellow members for any questions. I personally would like to know a little bit more about the Protect 33 situation, as much as you can divulge that's public information.
Sure, happy to. So we received a complaint in March of 2023, and the board then delegated authority to the general counsel to investigate it. It's typically, as I mentioned in our other Other cases and investigations, the general counsel, there's a firewall between us. And so we don't communicate except through public filings in our adjudication proceedings. And then we do, at least as it relates to case matters, we do discuss outreach efforts and things that do not involve specific cases. This is a bit of a unique structure because it's not in the Agricultural Labor Relations Act, and it's structured differently. The board, we're run like a court, and so the general counsel has the staff that actually can do those investigations. So they investigated and had various communications with the union, which were made public in their filings. They issued basically an investigative report to the board. And their recommendation, based on their review of information, was that because ProTech 33 was not currently engaged in any organizing efforts and there wasn't any evidence that they could do so, intended to do so, had done so, they recommended that we not find that they are a bona fide labor organization. So when we reviewed that filing, and this is discussed in depth in our decision, or excuse me, that report from the general counsel, ProTech did file a response to the board. So they were able, once they saw the report, to file a response for our consideration as well. And on reviewing those, we found that there were a lot of inconsistencies between what ProTech said, either during the investigation, what they would say publicly versus in other forums. They were part of another larger union. It was frankly fairly confusing. They were kind of went by multiple different names with officers that would maybe be a president in hold one elected office under one name and another elected office under another. And they just were not forthcoming with information. They presented that they they represented workers in other states. That's public information, but they would not share what companies they represented workers. And that to us was indicative of that something was possibly amiss.
But would it be correct to assume that the license holder signed this LPA and then the employees never met with anyone to organize? How do you know that how do you find out that they didn't try to organize?
So they did present some evidence where they said they had gone on an organizing trip to California and spent time talking to some of their licensees. They didn't say which licensees they spoke to. This complaint specified a specific dispensary in the Palm Springs area, and they didn't present any evidence relevant to like what they had done with that shop. Now, I do want to know, as mentioned, some organizations may have LPAs with a variety of licensees, and I understand, between money resource, financial resources, time resources, likelihood of success, et cetera, a union may not try and organize at every single licensee. I think one of the things that for the board was ultimately really telling was there was no evidence that there was, and also unions will not necessarily want to divulge who they're trying to organize, which we totally understand. But there was no way for workers at any of these places to find out about this union. And that's something that really kind of was striking to us.
So they're public facing.
Yeah, like even they didn't have they had a Facebook page that they said they didn't update. They didn't have contact information. Again, they went by multiple names, so it wasn't even sure who you were dealing with. And it wasn't just that they didn't have an office in California. I understand some organizations, if they're active in, say, another state, may not kind of outlay those resources to be physically here, but they didn't seem to have a way for workers of these businesses to get in touch with them.
And there are a lot more of those organizations out there than just ProTech, I assume. Are you aware of?
I can't comment on that. It's not really my place, but I have read various articles that discuss that there may be other non-bona fide labor organizations. Until we get a complaint and are asked to investigate, it's not really appropriate for me to opine on that.
Thank you. That's all the questions I have for, please, fellow members. Any questions you have, feel free to take the floor.
In terms of finding out if the organization is bona fide or not, does this apply to all the licenses, like laboratories, manufacturers as well, or are you focused only on dispensaries and agriculture?
I believe it's cultivation licenses. I might ask our DCC folks or others to chime in. Cultivation, retail, and manufacturing. I don't know about the labs. I don't know if anyone else that hasn't.
It's all of them.
It's all of
Just
them.
Joe as
Okay,
well.
so yeah,
Just
the labs
you
too.
as well.
So if an employee from a laboratory couldn't find its own information from, maybe they have a non-bona fide organization, they could then go to your organization to file a complaint?
Yes.
Understood. Thank you.
I have one question on the time frame. So what's the average or typical time frame from complaint to a determination? And then from the determination, you're done with it and it goes to DCC to do something with the licensee about correcting the if an LPA was determined to be non-bona fide?
Yes, so the board has 90 days from receipt of the complaint to issuance of the decision or the report to DCC. We met that time frame. There were some filing issues that extended it where not all the parties to the case were properly notified. So we made sure that once everyone did have proper notice of the complaint, that's when the clock started ticking. We're currently investigating our second complaint, so we'll see how it goes. But then DCC takes action, and I leave it to them to speak to about their time frame for taking action with the licensees.
Thank you.
Please, floor is open.
I appreciate so much the information. I think you presented it in clear and concise fashion. Also, I think it gives a good place to start. I know with another presentation to talk about. I mean, we're really talking about access to workers. I know I work for a labor union. It has offices throughout the state. You have to go in to file your pension, your health care. Like, you need access to the union to be able to adequately and the members to adequately represent them. I know ProTech has been an issue we've raised repeatedly with going to and ALRB. And I think the leadership here and really protecting workers, it's not about, which union is representing them. And I really also appreciate that there's been a really concerted effort to look at maybe organizing efforts that don't come with like a big union that's headquartered in DC, but that we're supporting that as long as there's organizing effort. To me, that's business, right? If workers don't feel, the whole point is so that workers feel empowered. They can choose to have a union or they cannot. And LPA is not something the industry is giving to labor unions. It actually offers some protections to employers, strike sanctions and others. So it is a relationship, and I think you did a really good job of saying like it's a relationship between the union and the members. And sometimes that results in organizing activity in the union, and sometimes it's not. But when we have, and there's been lots of reporting, I think as a union who organizes in this space, there are many others that we hope to see some accountability and enforcement and regulation around. So I appreciate that the partnership between the DCC and the ALRB, I think from our perspective, has been very informative as we kind of make sure that the industry comes to compliance on the LPA in particular.
Thank you. Yeah, I really have to.
Definitely echo your point, and I want to know, so if there's only 2 complaints at the moment, and to your point, there's a lot more cases out there that all of us know about. So how come there's only 2 complaints? And those that have signed fake LPAs that haven't been a complaint filed about it, will those not be held accountable, or would that only show up at a license renewal? So how does it work for the people that aren't?
I can't speak to the licensing side. The statute that was enacted last year, AB 195, is very specific about who can file a complaint with the ALRB. And I'll say in any of our cases, even under the ALRA, we cannot initiate a complaint. We have to wait for a charge or a complaint in this case to come to us. So in the LPA context, complaints can be filed with us by a current or former employee of the licensee or a labor organization. And so far, both complaints were filed by labor organizations. That's a pretty unique requirement. I've been involved in other licensing areas where any member of the public can file a complaint. And frankly, you do see in regulated industries kind of the legitimate businesses will file complaints on businesses that they suspect are illicit in order to ensure that there's a level playing field.
Sure.
So that's something that I think, if there are legislative changes, could be considered. I don't know the rationale
So
for
the
that.
question for the DCC, do you now, knowing that there are so many fake labor organizations out there, are you going through the several licensees that are known to have those agreements, and are they getting notified? What is the process? Because it seems like you can kind of just get away with it if nobody files a complaint. Sorry to put you on the spot, but it's important.
No, I appreciate that. Unfortunately, we can't share information about ongoing investigations if anything is going on. But I think as they mentioned, with the ProTech one, once we received that notification from ALRB that somebody's been found to not be a bona fide, we immediately got the required notices out to the impacted licensees.
Anyone
so they
that
could
had
address.
everything.
Yeah.
Okay, that was my question. Thank you. Any other questions from the members? Well, then we can go to public comment, I suppose.
All right, we are
Thank you
now,
so much.
we are now taking public comment on agenda item number 5. The topic for this is on the screen. If you'd like to make a comment, please raise your hand by clicking on the hand icon next to your name if you've logged in, or by pressing *3 if you've called into the meeting. For our in-person commentators, please raise your hand and our audience moderator will work with you. When it's your turn to speak, you may choose to state your name, or you're not obligated to do so. You'll have 2 minutes to speak in a 30-second warning and 1 opportunity to speak on this agenda item. So with no further ado, we have an online commenter. Anna Guita, I just sent you a request to unmute.
My name is Ana Gaeta. I'm a representative with the United Food and Commercial Workers Union, UFCW Local 1167. Our local represents cannabis workers throughout Riverside, San Bernardino, and Imperial counties. I'm calling in this morning just to share a little bit about our experience in organizing cannabis workers and working with labor peace agreements. As we all know, LPAs were implemented early on as a way to promote the stabilization in this new industry. And a common misconception is that it automatically makes workers union members, and this is just not the case. So LPAs are intended to strengthen the relationship between both the union and the operator, and our local always works with these operators so that they understand that this partnership is intended to help the industries grow. And even with an LPA, it is still our responsibility to organize, speak with workers, and demonstrate that the majority of them would like to have union representation in their workplace. So furthermore, our union works purposely to ensure that we engage with operators, municipalities, and community members to walk them through the general intent of neutrality and what it means for workers in this space. Personally, I have had conversations with operators that want to learn more about what the LPA will mean for them and their business. And I've also met with operators that have simply evaded working with us and instead have signed an LPA with fake union, as was mentioned earlier, in order to simply check a box and obtain their license. And so we've also experienced instances where some operators have attempted to leverage us against another union. And
30 seconds.
I have also had operators claim that they have less employees than they really do. So they don't fall into the LPA threshold, or they simply will not talk to us when we've reached out to them with information about an LPA. And because of the lack of enforcement, these operators have been able to operate without fulfilling this requirement. So we find this extremely troubling, especially for cannabis workers. Enforcement is needed. Years have passed since cannabis was legalized in our state. And we know that many operators still don't have LPAs and won't have them unless there is some form of enforcement. So thank you.
Thank you.
Mitch Colbert, just sent you a request to unmute.
For the hearing today. Thank you so much for covering this important topic. I'd like to start by saying thank you, Anna, for everything you've done for the unions, for everything you said today. America is only strong because we're union strong. And unfortunately, the unions are really having a hard time these days, partially because of hijinks like this. I'm someone who's formerly worked with union groups in the past on political issues. While I worked at Harborside Health Center, I tried to unionize it, but a lot of employees had concerns because of, well, shenanigans like this, this kind of fake union shenanigans. It's been going on for a while now. This is not new. And this puts a bad taste in people's mouth. It makes real unions' job that much harder. Veteran cannabis journalist Chris Roberts has been writing about this specific issue since March this year, if I recall right. So we've known about this publicly for a good 6 months. Nice to see that something's happening, but I wish we knew more clearly what was happening. What is the enforcement against these people who signed these fake union LPAs? I'll openly say, if any of those companies are on this call, your customers are watching you and they are taking notes of you signing your employees down the river. There's a big issue with managers not respecting labor in the cannabis industry. Harborside was great, better than a lot of other dispensaries out there, but there were still sometimes when management really didn't have our backs the way they should have.
30 seconds.
They tried to ham-fistedly impose a tattoo policy that caused employees to quit because those employees were hired with tattoos that now went against the company policy. Had we had a union, that kind of stuff wouldn't have happened. So even at one of the best dispensaries out there, we still had issues that could have been helped with a real union. So please, keep America strong, keep our union strong. Thank you very much for talking about this important issue today.
Thank you.
Thank you.
We have an in-person commenter.
Good morning. My name is Kristen Heidelbach. I'm with UFCW Western States Council. I've had the pleasure of working in the labor movement for about 20 years and also had the pleasure of working on this committee for 4 years. And one thing that I learned during my time on this committee is that public comment is so helpful because they tell stories that otherwise other folks wouldn't know about. So I just want to tell one really quick story about my experience organizing in the cannabis industry with one particular large operator that we had signed a labor peace agreement with, which just gave us access to the workers. And we then coordinated with that company a good time to come out and have conversations with those workers. And like Anna said with UFCW, we've got a number of people who reach out to us, a number of workers who reach out, and they give us many stories, reasons why they want representation. So we gained access with the company. We worked with them. We came out, we set up a tent, we had conversations. People were really excited about what we were doing and excited about the possibility of being represented by a union. And once that employer found out and saw that we were signing multiple people and signing cards, immediately people were frog marched back out to the tent and forced to remove their name from the list. Organizing workers is not easy work. Just because you sign a labor peace agreement with a labor union, a bona fide labor union, doesn't mean that your workers are going to be unionized. It means that you still have to convince those workers that they want collective bargaining. And I just wanted to tell that story. Regardless, even if you get that labor peace agreement in your hand, it doesn't mean that the employer is going to work in good faith with you. Thanks.
Thank you.
Thank you. Tony, I've sent you a request to unmute. Go ahead, Tony.
This is Tony Bowles, and I have been in the cannabis industry for 20 years now. And I just wanted to talk about a couple experiences I've had with unions and organizing. So at one dispensary that's been around for about a decade now, definitely experienced the same shenanigans that went on at Harborside. Although staff wanted a union to form, it never materialized. It wasn't until a couple dispensaries later that I was actually able to work in a position that had a union contract. And when a robbery happened at the dispensary, they were forced to shut down. All the staff were laid off, and eventually they sold the company. We were told that we were able to reapply with this new company. We were immediately contacted by the union to let us know they were in breach of the contract and were filing suit. In the end, we were able to get severance for everybody, and I was able to witness how effective being unionized can be. So Yes, please support
30
real
seconds.
unions. Thank you. That's all.
Thank you. Last call for public comment on agenda item number 5. All right, Chair Jamalian, I see no further requests for comment. Would you like to close public comment?
Yes, please. And that concludes agenda item number 5. I suggest we take a 5 to 10-minute break and then tackle the cultivation subcommittee before lunch. We should be able to take an hour and a half. And oh, we have one more? Oh, but from who? I thought that was a typo.
No. Mr. Rod's presentation.
Oh, okay. I guess we have another presentation. Sorry, Matt.
It's okay. Surprise. Thank you, Mr. Chair and members. Matt Broad here on behalf of the California Teamsters. I think, first of all, I'd like to thank Chair Hasid and Mr. Blanco for their very in-depth and helpful presentation explaining how the LPA regime works in California, how it interacts with the ALRA. I know all of this is complicated, and as a union that we obviously are a bona fide union, we want to be a resource. We want to be helpful to allow licensees to navigate sort of some of the legal complexities here. Just really quickly, the two complaints that were discussed today, Protect 33 and the pending action, which I'm not going to speak about, were both brought by the Teamsters. I think, last year with the budget trailer language that sort of beefed up enforcement around labor peace agreements, what we were seeing is that in the industry, the labor peace agreement regime had become sort of a paper tiger where people looked at it as something they needed to do to check a box. And for us, that's never been the intent. And we clarified that in statute. We now believe that LPAs are a material condition of licensure. So that means that you need to have an active LPA, needs to not be expired. It needs to be with a bona fide union, and you need to abide by the terms of that LPA. And so we've seen over the years, there's been quite a bit of evasiveness and the proliferation of non-bona fide unions. We're fully committed to tackling that through enforcement, and that's what we're doing at the ALRB. Just generally speaking, what we've seen is if a union seems like it's not bona fide, then it's probably not bona fide. That's just the simple reality of it. Although these things, because of due process reasons, need to be litigated, and that's why we file the complaints and it goes through the process of the ALRB. They make the determination, but sometimes when we're looking from the labor movement at other unions, we know, for example, that there are unions that are legitimate. We're very sensitive to the issue of startup unions, where I would be the first to tell you that we want cannabis operators to have LPAs with any legitimate union. That doesn't necessarily mean the Teamsters. It doesn't mean UFCW, who's done a good job presenting and commenting on this today. It could be an independent staff union that forms. But where the real determining factor is if it looks to us like there's employer domination, if there's a wink and a nod that I'll sign this LPA with this union with the intention that no one will ever be organized. And finally, the biggest no-no, which absolutely should never happen, there should never be an exchange of money for an LPA in any way. I want to be very clear about that. A legitimate union does not do that. And so I know that there's, sometimes when people are looking at the sort of list of labor unions out there, there's not always clarity about who's bona fide and who's not. And I would just say, don't be afraid to ask. Reach out to a union. I'm sure UFCW has the same policy. We would have an amnesty policy where if you entered a labor peace agreement with a union that's deemed non-bona fide, or maybe you have questions about their legitimacy, we're happy to talk to you about obtaining a legitimate LPA at any time. And that's basically the heart of it, right? And I think Amber touched on it too, that just because you have a valid LPA does not mean that you have a collective bargaining agreement. It's just a sort of set of broad rules that that really dictate labor peace in the workplace. And that's in the shared interests of workers and employers and unions organizing workers. So with that, I'll just close. Thank you for the time. Happy to answer any questions from either board members or maybe if we want to open up public comment again. But thank you.
We'll open up for public comment unless any of the
I do.
members have a question.
I have a
Thank you.
question. So I kept hearing from the previous people that did presentation and from you, like about bona fide, right? The bona fide thing. Why isn't there like a database that says this is a bona fide group that you should talk to? Or why isn't there somebody that says, we've done the research, and so when somebody approaches you about an LPA, you have a place to go look it up and be like, is this an actual group? Because that seems to be like, you know, as a worker, I might not know that person isn't a bona fide person, and I wouldn't know exactly who to ask to find out. So is there anything like that, technology online?
That's a good question. I think you can obviously always use the internet to research. We want to be very careful about there shouldn't need, in my opinion, need to be a list of who's a bona fide union and who's not a bona fide union, because we don't want to track people to one union versus the other. We want to have total free choice. And again, at the issue of a novel union, right, that maybe doesn't have members yet, they're just forming, they're in the process of getting their first contract. We wouldn't want to preclude them from being deemed non-bona fide. I will point out that with respect to the labor peace agreement regime, it's a agreement between a union and an employer. And so the concern is that the employer is dominating the relationship between what we would say is a non-legitimate union, non-bona fide union, and their employees. And so really, the reporting mechanism that's in law right now is for unions or employees to raise concerns about potential fraudulent unions. But if an employee ever wants to organize, they're always free to do that. They're always free to reach out to a union. What we're concerned about is that, like I said, the wink and the nod example where I have an LPA with a non-bona fide union, and there's a handshake agreement that the union's never going to come around. And that's what we're trying to sort of stamp out and make sure is properly regulated.
So how do we assure that the people that have those agreements are bona fide unions?
Sure. So that's determined by bringing a claim with the ALRB, which we're doing, right? And part of the problem is that when we first stumbled on this, we weren't sure about how pervasive it was. Chair Hossid mentioned that there had been great effort by the DCC and really fantastic effort to sort of compile the lists of LPAs and license holders. And in doing that, we were able to see that it's much more pervasive than even we thought, which is interesting. And I would expect us to pursue more claims should the validity of a union come into question.
Okay, thank you.
Please.
To expand on Ms. Della Rosa's question, is there a licensure process that bona fide unions have to comply with in order to become a bona fide union, whether they're just a startup or whether they're, experienced or have 5 or 6 or 10 years? Because I would think that once they have gone through this licensure process, that they would be on a list of bona fide unions, whether they're just a startup or not.
Yeah, so that's another good question. Basically, the way the statute's structured is the ALRB makes the determination of whether a union is bona fide or not, because they have the ability to assess that and the expertise. But there are things that real unions do, like federal filings, that confer legitimacy on. A lot of times the gray area might be that they're doing some of the stuff, but they're not doing all of the stuff. And they're making minimal effort to comply, but they don't have real members. or they're not actually trying to organize workers. And that's where the sort of fact-heavy determination would come in, where you would have to assert a claim, and then a charge would need to be brought, it would need to be investigated, and based on the facts, the board would make a determination on whether the union is bona fide or not.
Does the California Teamsters plan to have a list of bona fide unions moving forward?
That's not something I've considered, but we're happy to. I think that we've told other operators that there are other legitimate unions in the space, and if they're not interested in an LPA with the Teamsters, they're happy to go pursue them with other legitimate unions. But that is something we would consider going forward.
Yeah, I was just I am not an attorney, so I will defer to the ALRB on this. We have tried to codify bona fide labor union, but there's some legal reason or challenges to that. I would also say there's a structure of the AFL-CIO and also the Labor Fed, of which the Teamsters are a member of, so they can tell you who is an organizing union in California, and they can tell you legitimately who belongs to the Labor Fed. And I would say that has been something we have offered up in the past. Not every union is part of AFL-CIO, but most unions are affiliated with the Labor Fed. And then I think they laid out some really good ways. I would say that if a union has a website, if they, are organizing, if they have officers, if they have bylaws, those are pretty basic requirements. And I would say in our research almost a year ago around ProTech, they did not have any of those. And if you just scratch under the surface, and this is like, us just like, oh, they have an office in Fresno, no one's answering the phone, these people don't live here, like no one knows them at all. So I'd say there have been concerted efforts to put forward these fake unions and saying, we can get you around the LPA requirement. And I would say any conversation that starts there is not going to end in a bona fide labor union. And also like an LPA to us is a conversation. I think Anna from UFCW testified in public comment that we have employers come to us all the time and say, like, how do I navigate this? I know the DCC offers technical advice on this. So there are lots of ways that you can pretty easily suss out who is a bona fide labor union and who isn't. I would say any confusion about that point, and I think you spoke to it really well, Matt, is like, that's confusion for a reason. These are not bona fide labor unions. And again, like the conversation is about an LPA. It's not necessarily about organizing effort for sure, but it's pretty easily, you can easily tell who is doing organizing or has conversations with workers and who doesn't.
I would argue that some of us industry operators deal with a lot, and researching whether an LPA is legit or not would be a lot easier if there was some sort of list.
That's fair.
And I don't think asking for a list is really asking for too much.
No, I don't think it's asking for too much, but I'm saying like, again, I think I speak for UFCW and the Teamsters, we try not to say you have to go with us. That would be a.
Well, no, I understand the fair business.
So we are very well aware of other unions that are
I think
organizing.
if it's part of the licensure, and like you had just said, it's now a vital part, a material part of this licensure. Just like they tell you how to get a life scan, I think you should be able to say, hey, these is a list of bona fide organizations that we approve of.
Absolutely. Great.
And I think the current situation, what happened here, would also suggest that it would probably be good to have this list and not have people fall for a ProTech. So I think that, when we talk about the cannabis industry, we treat it like this mature industry that has all the other luxuries of every other industry when we don't even have banks. So I do think like expecting us to scratch the surface when we have to play a banking carousel game amongst other things, it's just too much. Let's get a list out there. It's really not that hard. If they're going through a licensure program, should be able to get published. Who made it through the license and who not? My address is published for anybody to come break in. So I mean, can't be that hard to publish a association.
I represent DCR, and so how do we ask our operators to be in compliance with their labor peace agreement if they don't have any kind of database from which to check? Yeah.
Well, again, it's something that we can consider it, on their part. Part of the reason I'm here is to to sort of, give this message of amnesty of we're not trying to go after and enforce against good actors who are confused, who maybe lack the sophistication to determine that union's legitimate versus non-legitimate. I'm certainly sympathetic to the fact that that may not be an easy determination for everybody. We're interested in enforcing against bad actors who are really doing this as part of a concerted effort to undermine the LPA regime. And so you can always reach out to us. I haven't posted my contact information. Happy to share that, or happy to share folks from our organizing department. And I'm sure UFCW or any other legitimate union would do the same.
Sorry. Are the LPAs for each group public domain? Like if if a company signed an LPA, are we able to go look that up?
You can now on the DCC's website under the LPA data bank, if you want to call that, you can actually see who has an LPA with whom. And I can't remember, are they publish the actual LPA itself?
You can request.
You can request.
Can you require that the link for the union be in the LPA? Because I know we're talking about unions and all that good stuff, but I'm concerned about workers. And my thing is that workers are not going to scratch the surface. So if they go and they're like, I'm having a problem, there's enough of us within this organization to organize. So let me go see who our LPA for my organization is with. And then they go in good faith to a group, and I think you were hinting at this, that create the union, we'll sign the paper, we'll give you some cash. That's kind of what I'm hearing. I'm not saying that that's what you said, but that's kind of like the undertone. So if I'm a worker who's working an 18 to 20-hour job, and I'm like, I need to organize. There's some bad actors and we have bad working conditions and we're required to do all these things that we shouldn't be able to do. And I go to that person and say, hey, I'm interested in organizing with the union that my company signed the labor peace agreement with. And they're like, yeah, we'll help you. And then turns right around and goes to the organization like, oh, this is a problem person. We need to start writing them up right now. So I want to give some autonomous to the worker to be able to go look it up and be like, is this a bona fide labor? If I go to them, am I risking my job? Is this somebody that somebody in the union world has vetted and I should feel comfortable going to them? Because I think as we see more of these cases come up, you're going to be scaring workers even more. They're like, oh, that wasn't a real thing. So if I go to them, I could lose my job. And I just think that we have to have, give them agency to be able to look that up and also have a place where they feel like, yes, this is a bona fide union. This is not a fake union that's working with my employer to make sure that we never organize. And I think as we've seen with the HHS coming on Thursday, this is barreling down for our workers. It's barreling down this road that we have to kind of figure out. And instead of thinking so much in terms of what the organization is doing and the LPAs, how are we protecting the workers as these unions that are bona fide to make sure that they feel empowered? And I think we're seeing a huge labor movement in the US across a lot of different orgs, the airline pilots, the hotel workers in LA, like so much stuff is going around about labor organization that we should have it at the, just as the chair said, we should have easy access to understand this as a cannabis industry that is not mature. It is very much in its infancy, but we should have that because we have a moment where we might lose the ability to organize if we are not playing with the good actors.
Thank you for all those points. They're well taken and something we'll certainly consider going forward. I just also want to be clear. I'm not accusing anybody of exchanging.
I know.
Yeah. Money.
Just like the undertone.
Yeah.
The undertone.
Yeah. No. I just want to be clear that we're just trying to make sure that the law is enforced the way it was intended, the way that it's written, and so on and so forth. Did anybody else have a?
Yeah. Just curious, is it very common for employee-driven organization to occur? Because I heard that was one of the concerns originally with not having a bona fide list is what if the organization actually comes from the workers themselves? And so I'd just be worried that there might be some unintended consequences of making that list and then putting up roadblocks for employee-driven.
That's exactly right. That's my concern actually in thinking about it, is that we really don't want to traffic people to certain unions. I frankly wonder if there are, potential legal concerns with that. Also, to your point, we're in this moment of sort of labor militancy, which is great. We want to encourage workers to organize in traditional and non-traditional ways, and non-traditional ways could be forming a union, doing it yourself, the so-called sort of startup union. We've seen it pop up all over the country. There are obviously challenges with that, because I think it's maybe harder to organize that way, and that's why you see it less common. But we want to make sure that those workers have a chance to organize in whatever way they're comfortable with.
I guess I'm curious, to anyone's knowledge, do those exist right now in the cannabis world in California, or?
I'm not familiar with them existing in the cannabis world yet, but we would certainly encourage workers to form a union.
Yeah. My question was along that same line, because if employees form a union or join a union that, is questionable whether it's bona fide or not, are we as employers violating labor laws by telling them that's not a bona fide union? Right? Could we divert them to a different union if we thought it wasn't bona fide?
No.
Yeah.
My sense is, if my advice, and this is not legal advice, is if workers are organizing, it's best to just let them organize and comply with the law and not traffic them to one organization or another.
Well, it sounds like that's not a problem that y'all are seeing.
No.
I would say we're talking about non-bona fide labor unions. They don't necessarily organize, and that's part of they don't meet that litmus test. So if you're having workers who are organizing with some union, then that's probably doesn't, I would imagine.
Well, if a startup union we're talking about a potential startup union within a cannabis business, they wouldn't be bona fide yet.
Well, yeah, and I think that's why.
And then could you do an LPA with them, and that's if they organize from within?
Yeah. Yeah, you want to add.
But wouldn't that violate the fact that it's a non-bona fide organization?
Well, I'll let.
And then you would be able to certify them, or whatever that process is that doesn't get published.
So I think one of the things that we're seeing is there isn't, and I appreciate that's frustrating, as multiple members of the committee have suggested. I completely hear, and I want to try and think of a way to provide a resource that licensees can go to so they know they're working with bona fide organizations. As Matt alluded to, there could be legal considerations for us as the adjudicator of determining whether someone's bona fide. It's not appropriate for us to prejudge someone and for us to put out that list. And so I'm kind of brainstorming in the back of my mind of what could happen, but.
If it is not bona fide, I mean, you've done now.
If it's
Yeah.
if there's a complaint.
We review the complaints and make the decision.
Only if that's kind of the catch-22.
Yeah. But I hear you. One thing that I do want to speak to your point about worker knowledge. We've been really pleased to engage with DCC as they're preparing for their rulemaking to implement other parts of AB 195. And one recommendation that we made was to put a requirement that employers need to post or provide the LPA with a copy of the LPA that they have, as well as contact information, and also provide it, there's a lot of workplace postings, but provide that information in a way where workers could access it and not necessarily have to self-identify themselves to their employer. So that's something that, just an idea for now, but one consideration. I think so. There's a lot of employee notices. You all get that packet where you spend your first day at your job filling out paperwork, and that could be something that could be added. One thing to speak to this other question about steering, and Matt was right. You kind of want to, again, I think it's a best practice to not try and steer your employees to a particular union. But I think as a licensee, as you're doing your due diligence, an LPA is an agreement. It's almost like a contract that you're signing. So when you're engaging in that process, that relationship, as others have referred to, you can and should ask questions like, Do you have LPAs with other people in the cannabis industry? Either in California or not? Have you had any organizing campaigns? Have you won any elections? Do you have contracts? Do you file federal forms as required by the Labor Management Standards Act and things of that nature? I want to caution that, as we've discussed, because we are trying to make space for, again, this like grassroots union, those are not always going to be determinative. In its history, ProTech had had made some of these filings, but we found that there were other factors that were more prevailing that showed, at least for purposes of MCRSA, they were not bona fide here in California. Additionally, one thing that I've discussed with others that I don't believe has come up is, I'd be curious if you've been approached by multiple unions, but a labor peace agreement does not preclude you from having multiple labor peace agreements. So you may be approached by a union, or you may approach a union as you're getting licensed, and you can still sign a labor peace agreement with another union. And in fact, if an employer decided to not sign with a union, that could actually be the basis, at least under our act, for an unfair labor practice charge. So totally different, separate. So for the cultivation licensees. So those are other things I think to think about as you're sussing out. And I appreciate all the different requirements that licensees have and the amount of work it runs to just run a business. I've never done that because it seems too hard. And so you want sort of ease of being able to fulfill that requirement, but it is a contract that you're engaging in that directly impacts your workforce. So it's one that you do want to do due diligence onto.
I have a quick question. So I think you mentioned earlier that bona fide labor unions are going to also have bylaws, right? In addition to the list that you just shared with us. So would it be a red flag if we asked someone or that was purporting to be a labor union and they wouldn't provide us the bylaws? I mean, would most unions provide those bylaws to show verification that they have them?
We're talking about the employer right now asking for it, because the employer has to sign the L.
Yeah, the employer.
I think it could be. I want to be cautious about giving a bright line rule, which I appreciate is frustrating. I totally get that. But, again, if there's a startup organization, they may not have a bylaws yet. They may be still formulating. But many labor unions that have been more established and that have elections and officers have bylaws to govern their process, similar to how other government bodies or organizations do, or like a nonprofit. So I think those are kinds of things that you can ask about, and bylaws are public if they have them. And if they're not, that's a concern. Thank you.
So I have a question regarding, it appears that there's a presumption that an organization would be bona fide until they're determined that they're not. Since there is no list to say that there are, I mean, you could pick a couple of names that you might have heard being represented in the room, but if they're not one of those and an employer signs with someone, until they're deemed not bona fide, the LPA would stand, I'm
Yes.
guessing.
Yes. And as I learned about, and I haven't had as much experience with this, and Ed or someone else may want to discuss it a little bit more. Some of the local jurisdictions have also had this bona fide requirement. The city of San Francisco, there was an issue. It doesn't necessarily mean that the state is going to adopt that local jurisdiction's criteria, if you will. But I think, I don't know if anyone else besides San Francisco makes that determination, but that's one jurisdiction that has.
I represent a jurisdiction where we've been tasked to look at this, but we're not the determiner. We're relying on the ALRB to make the determination of bona fide or not. But our businesses have, some concerns about, well, how do I know? And if I understand correctly, what's gonna happen is if they make a complaint, an investigation would happen, they would be determined to be bona fide or not. If the answer is no, they're not bona fide, the business would have some time to then seek a remedy with another organization to meet the requirement. They wouldn't be instantly have their license pulled. Because that's my understanding of the DCC's approach to these. But to that extent, once a determination has been made and the employer has been told, hey, the LPA that you have is with a non-bona fide labor organization, is the local jurisdiction also going to be notified of that? Is question number one. And then two, the flip side, if the determination is yes, that is a bona fide labor organization in that example, would that then lend credibility to that organization throughout the state? And would a future complaint be more quickly adjudicated? To be like, well, we've already investigated them and they're good? Or would there be a new investigation if another part of the state complained about that same organization?
Yeah, in regards to your first question about notifying local jurisdictions when there has been a finding of non-bona fide, I don't know if the DCC has taken any action. One thing we've just discussed generally amongst ourselves is it would be great to have more of kind of like a interactive map, an online resource to know which jurisdictions have offices. I know like Palm Springs, I think also has an LPA requirement. I don't know what jurisdiction you represent.
San Jose.
San Jose. Okay. See, new one as well to me. And I think they're all a little bit different. And so having a better understanding, like a statewide picture, that I know would be helpful for us. But I think we could certainly work with DCC about how to provide notification. I was really appreciative. DCC took, they on their own issued that bulletin to all the licensees, which I think was really helpful after our first decision. And we can have further discussions and I think would be receptive to input about other ways to communicate. In terms of the presumption of bona fide, I don't think it's appropriate for me to speculate on that. And you could easily see an instance where maybe an organization as a union as a whole, like a national is bona fide, if you will, but a particular local has an issue. And so I think there are a myriad of ways that it could transpire.
Thank you.
It seems to me this is a problem in the industry because a lot of companies are afraid of their employees being unionized. That's why you would seek out a fake union to sign an agreement with. What are labor unions doing to educate on the benefits of unionizing to the industry?
I'll turn it over to our Teamsters representative.
And I say that, because a lot of licensees are social equity licensees who, before they were owners, many of us were laborers, right? And so I think there's that sympathy, but we're also small businesses that are afraid of things that will impact our bottom line negatively and weighing that, So what are labor unions doing to educate on how, that grows the industry overall?
Sure. I think that's a good question and something that's certainly worthy of being sensitive about, that when workers organize and it lifts the tide for all the workers, that can have added costs to business owners. We're, not in any way in denial about that reality. I think that the Teamsters are primarily a private sector union. We represent workers all across the various industries, from cannabis to lifeguards to truck drivers to UPS drivers, you name it, to zookeepers. And we want to see our employers be successful. That's the truth, is that when employers are successful, workers are successful. And it doesn't necessarily need to be an adversarial relationship with employers. In fact, it's often not an adversarial relationship. Sometimes it is. That's the nature of employer-employee relationships. But sometimes we work very closely together to make sure that our employers are protected. Obviously, there are lots of things that are happening. We're talking about an emerging industry where things change, it seems, by the day. And being in contact with our employers and understanding what's important to them, and ensuring that they're in the long term successful is in our interest. And so, we have many longstanding relationships with employers that are great, where we never have any issues with them. Obviously, not every employer is created the same. Some are good, some are bad, some are great. But typically, where we can, we work to see the employer be successful as well.
Thank you.
This is actually a question for the DCC. Someone could answer. So once they determined that Protect 33 was non-bona fide and that the DCC sent out the bulletin, were the companies that were signed up with this particular non-bona fide union then required to fill out another LPA with a bona fide union, or risk losing their license? Because they weren't able to get the license without the LPA. And then they've been under this false LPA until they got caught. So what was the requirement from the DCC to make sure that they had an LPA with a bona fide union for that group?
Do you want to answer that? I know you already said it earlier, but if you don't mind repeating it again.
So
I think it's been mentioned, we did send out notices to comply. to
Okay, I'm
those
sorry, I missed
businesses
that.
Impacted.
Yeah,
no
yeah.
Problem.
Thank you.
Like, I can't give any more information than that, but we
Okay.
can set the
Okay,
notices
thank
to
you.
comply.
And just in terms of the actual statute where we did this, there is a process by which an employer should be notified and then encouraged to go seek out a legitimate LPA. So I don't view it as a world where if you get dinged for this because you're unsophisticated or you made a mistake or whatever reason, let me be clear, we're not trying to come after employers because we don't want them to be successful. We just want them to play by the rules where they're not. And for the majority of licensed operators, that's not an issue at all. And so we're really not concerned about that.
Thank you. And I think we could probably go on with this discussion for another 2 hours. I'll yield the floor to you in a minute. But I do think we have our takeaways. I think our major takeaways here are that we probably need to do some sort of recommendation around this to the DCC. With that, you'll have the last comment before we go to public comment.
Thank you so much. Does the DCC plan to notify employers through their renewal licensure process and find out if they have their LPA with a bona fide union? How does that work moving forward?
There's a number of times throughout the process where they have to notify. So like if they change, there's a notification at renewal, you have to provide notification. So, and we'll be developing regulations.
So that's happening on the state level. Local jurisdictions are not responsible for that?
It doesn't, local jurisdictions could certainly have that as one of their requirements, but the state requirements are the ones that are spelled out in member. So.
Okay, thank you.
And we do in San Francisco, for example, but what you do when you're submitting for a renewal, you have to resubmit all your documents. So if you are to have an LPA with one of the illegitimate ones, they would see that upon your renewal and probably flag that for you, right? I mean, they looked at all my documents. They definitely, yeah, the licensing, they will review every single document. So there is a couple of safeguards, but I think the point is we didn't know who these egregious actors were before, right? Yeah. So with that, could we open for public comment, please? Thank you. Thank you, Mr. Braun. Thank you so much.
All right, we're going to open up agenda item number 5, reopen this for public comment. And just remember, you can raise your hand by clicking the hand icon if you've logged on, or by pressing *3 if you have called into the meeting. And if we have any in-person commentators, we will work with you here. So with no further ado, Jay Johnson, I've just sent you a request to unmute.
Hello, yeah, I just wanted to weigh in on this conversation, this topic. I think it would definitely be beneficial to not only the workers, but as a license holder and operator here in California, to have some list readily available and not showing preference to certain unions over the others, but just a basic list of these people have gone through whatever precedent or licensing, but just showing that they're legit. Because, as an owner operator, as I start to get at that plateau of having a certain number of employees and letting them have their LPA agreements and union things, what scares me just hearing this conversation is if I block some quote unquote reputable union rep from coming in, and then I'm breaking the law on some things, and then that comes back as blowback to me. But being an owner operator, security is of the utmost importance. And right now in the industry, a lot of us retailers are being robbed at an alarming rate. So we're not just going to let anyone who just says, hey, I belong to such and such, I need to come talk to such and such, for a security reason, and also just to make sure that they're legit, that they're not leading our employees down the wrong path. And that's just going to be a hornet's nest that gets woken up. So I don't think it's too much to ask to have some list readily available. To get my license, I have to submit so much information year in and year out and on a quarterly basis to the CDTFA. That just having a list available of, hey, these people have gone through whatever program or been validated by whoever, that we can easily find and look up and say, okay, yeah, let's have them talk, or let the employees meet with them, or whatever it needs to be. But
30
yeah,
seconds.
I think there definitely needs to be a list. Thank you.
Thank you. Kimberly Cargile, I've just sent you a request to unmute. Kimberly, there you go.
I was wondering, I'm from the city of Sacramento. My name is Kimberly Carlisle from a therapeutic alternative, and I really appreciated, I think it's Ed Waters' comments about what businesses should and shouldn't be doing. And I'm wondering if he could also reach out to the city of Sacramento, if he hasn't already, to provide education to the businesses. Because I think most of us don't know that we're not supposed to be in the meeting with the, be in the meeting with the labor organization, or just the little things. We don't, there's not like a rule book on this. We just signed this labor peace agreement and, hope that we're doing everything right. And we want to do everything right. We just don't know what the rules are. So if there's any way that you could provide some education to the businesses in the city of Sacramento, we'd really, really appreciate that. Thank you so much.
Thank you. Anyone else have a comment on agenda item number 5? All right, Chair Jamali, it looks like we have no more comments on
Thank
part
you.
2.
That concludes agenda item number 5. I think some sort of best practice graphic might be something you guys could do. That's what we're hearing a lot. But with that, we'll close agenda item number 5 and take a lunch break for an hour. We will meet again for the cultivation subcommittee, which is a bit of a more extensive point today. Thank you. Or we can take roll, please.
Yes, sir. Member Bauer,
Present.
Dr. Brown,
Present.
Member Brown, Member Christensen,
Present.
Member Clifford, Member De La Rosa,
Present.
Member Frazier,
Present.
Member Iramoto, Member Paya Pearson, Member Polson,
Present.
Member Shockley,
Here.
Member Tupy, Member Woolsey,
Present.
uh, Vice Chair Nevedall,
Present.
and Chair Jamalian.
Present.
Quorum is established.
Thank you. The next item on the agenda is the report from the Cultivation Subcommittee. Vice Chair Nevedall, floor is yours.
Thank you, Mr. Chair. So the Cultivation Subcommittee met earlier this week to discuss some specific questions posed by the DCC related to appellation of origin and the upcoming program. Some background on the appellation of origin program. The California Department of Food and Agriculture is responsible for implementing the appellation of origin program for cannabis and cannabis products. CDFA has promulgated regulations that describe how cannabis businesses can request that CDFA establish an appellation of origin. And as the oversight authority for the packaging and labeling of cannabis and cannabis products, DCC will establish regulations on how appellations can be used in the context of packaging and labeling. The subcommittee passed 5 motions for the full committee's consideration. And with your permission, Mr. Chair, I'd like to read out all of the motions for the committee's consideration, then present the motions one at a time for discussion, public comment, and a vote.
Yes, please go ahead.
All right. So the first recommendation we passed on Tuesday is a recommend that the DCC adopt a tamper-proof, unique in appearance, such as holographic seal, ideally embedded with a QR code. The second recommendation we passed was to recommend that DCC adopt regulations for labeling requirements to require the appellation name followed by the term appellation on the primary panel of the label. For manufactured products, the recommendation is to include made with, followed by the name of the appellation, and then the term appellation on the primary panel. And the third recommendation is a recommendation to have the DCC adopt 1 year as the appropriate transition time for businesses that do not meet the appellation of origin requirements, but are for some reason utilizing an appellation name before the appellation was established. The fourth recommendation was to ask the DCC to develop different penalties for the misuse of the appellation name or seal and for counterfeit seals. Both shall be no less than $500. And the fifth recommendation was to recommend that the DCC require that each appellation of origin producer maintain a copy of the approved petition and the public notice of approval, on site at all times, and to make that paperwork readily available to the DCC for purposes of inspection. Now, it's a lot of motions or a lot of recommendations, so we'll go back to the beginning and we'll just start with number 1. So the first motion, or the first recommendation, which I'd like to frame as a motion, is that we recommend that the DCC adopt a tamper-proof, unique in appearance, such as a holographic seal, ideally embedded with a QR code. So that is the motion on the floor for the first recommendation. And perhaps there's a second.
I have some questions.
At first, there would be some question and discussion. So if any of the members have questions, we'll just.
So I'm assuming everything with your recommendations are related to the Appalachia project or.
Appellation program?
Yeah, program. With the QR code or whatever the holographic labeling is it then gonna link to something else to explain Appalachia? Like, what is the purpose of it? Because I don't hear Appalachia in the first recommendation.
Right. So the purpose of having a unique tamper-resistant seal is to help the consumer identify that the product wearing that tamper-proof seal is from or produced from an appellation of origin that's been established, right? The QR code embedded within the seal itself would allow the consumer to obtain additional information about that appellation of origin. So they could essentially scan the QR code. It could direct them back to a CDFA page that would then allow them to understand the unique qualities and or standards associated with that appellation product.
And then the CDFA would be the one administering that page.
Yeah, the CDFA has the authority over the program. However, Department of Cannabis Control has authority over the packaging and labeling components.
And I know that somewhere there's going to be some sort of approval of this, that you match the appellation criteria. Wouldn't the QR code just lead to that certificate that's already, that says, hey, this guy got this
Perhaps,
certified?
but in order for that to happen, the QR code would have to be unique to each appellation, right? Which could be potentially more costly.
Okay.
So that would be one way to do it, but the CDFA is also supposed to maintain a web page that helps the consumer understand the appellations that have been formed and the unique standards associated with those appellations.
And they're aware of this probably coming their way, I assume.
CDFA?
Yeah.
Oh, I'm sure. I imagine that they've been working closely with DCC for some
Yeah,
time.
I think you're right. It makes sense to have one QR code for everybody and go to a website that explains what you just put.
So the recommendation is the DCC develop a seal, and then those seals would only be available to licensees who have met the criteria to carry the seal on their product. Is that the idea of
Correct.
the program?
Correct.
And that would be in addition to any other seals or labels or QR codes that are required on a given package.
Correct.
Okay, thank you.
And how do you gain access to the seal? Can I get a seal before I'm actually approved, or do I have to be approved prior to?
I would think you would need to be approved by CDFA, and that the notice had gone out to the public for that the appellation had been established before a seal would be available to the producers of that region.
Is there a second for the motion?
Second.
Thank you.
With that, we open up for public comment.
Very well, we're open for public comment on the motion on the floor. If you'd like to make a comment, please raise your hand by clicking the hand icon next to your name if you've logged onto the meeting, or pressing *3. For our in-person commentators, please raise your hand and our audience moderator will work with you. And you'll have 2 minutes to speak with a 30-second warning. Jeanine Coleman, I've just sent you a request to unmute.
With Origins Council, and first would like to thank the Cultivation Subcommittee for the meeting that we had the other day and the excellent work around this. Really appreciate it. We would like to support this recommendation. However, we would like to speak to a request that we have to not include in the recommendation the applicability of the seal or any labeling regulation pertaining to manufactured products. We believe that this is an issue that requires significantly more policy research and stakeholder input, and really impacts the integrity and viability of the program as a whole. And so we would like to offer that specification in our support. We support it for use on non-manufactured cannabis products. Thank you very much for the opportunity to comment.
Thank you. Any other comments?
We have one comment in the room.
I guess for me, it's just a clarification exactly what information would be included on the QR code. Is it simply just origin? Does it go into more detail of how micro or macro is it essentially? And I kind of wonder I see why this helps marketing and branding and things like this, where people can tie it back to somewhere. But I also wonder, there's a lot of white labeling and things like that going on, and that can affect how that transpires essentially. And so I'm just curious what information would be pertained on that QR code, how specific?
Thank you.
Thank you. All right, looks like there's no more comment on this motion.
Thank you. Seeing no more comments, can we please get a vote on the motion? Sorry, go ahead, Mahmoud.
Does the appellation of origin program follow a product downstream through, so a cultivator that meets the criteria transfers their products to a manufacturer who extracts it, who transfers it to another manufacturer, who puts it in a thing, and that person's in, the opposite end of the state, right? Nowhere near the appellation. Does that appellation of origin follow that, and would the end product be getting this, be eligible for the seal? And is that a different conversation?
It could follow that way. So I think there's, within the appellation of origin regulations produced by CDFA, the appellation itself in their petition to the state could require that the products be prepared or prepared into final form within the appellation, but they could also allow for white labeling, so to speak. So it could go from a cultivator, say, to a processor outside of the region, the appellation region, for to be put into a final form product. The material also, according to regulations, could go from the cultivator, say, to a manufacturer to be turned into an extracted or manufactured product. So that's currently what's in the CDFA regulations as downstream opportunities. But again, that's really how that's managed is up to the appellation and how they frame their petition, essentially.
Okay, this seal would apply to any of those products that meet the requirement.
Correct. That's the intention.
Got to follow up on that. So if you're a manufacturer that, is buying product from an appellation, could you then use this seal, irrespective of the cultivator, agreeing to that or being part of that?
Again, I think it really depends on how the appellation petition is framed. So if the appellation allows the cultivator to take the appellation grown product to a manufacturer outside of the region and utilize that product, and the manufactured product is 100% from the appellation, or has cannabis 100% from that appellation, then yes, I would think the manufacturer would be able to apply that seal to said product.
But they would need permission from the cultivator? Or?
It's really dependent upon how the petition is framed. So if I'm framing an appellation petition, you have the option as the individual or the parties that are framing that petition to require the products be completely processed into final form within the appellation itself, or you can allow for them to be processed into final form outside of the appellation. So if you were a manufacturer who was getting product, say, from Sunrise Valley appellation, right? And that appellation does not allow for the use or for products to be manufactured or processed outside of the appellation, then as a manufacturer, no, you would not be able to use that seal. But if the appellation allows for products to be processed or manufactured into final form outside of the appellation, then, and you were using 100% appellation grown product from that region, then yes, you would be able to utilize that seal.
I think to kind of frame this conversation, these motions are around establishing an appellations program. I think they're not quite at the point where you're getting as granular as, because you still have to file the application with the CDFA. So Mendocino might do it different than Humboldt. And so I think this is really just to establish a framework to go ahead and get this appellation program off the ground.
Yep. And the goal here really with a seal is trying to create a universal, unique identifier for the consumer, right? So it's easy to recognize that the product they have in hand is an appellation product, right? Whether it's a non-manufactured product, then they know that 100% of the cannabis came from an appellation, and then they can read the panel, the primary panel, to determine which appellation that product might be from, right? And the same for manufactured products.
I got that. I think the concern would be people kind of counterfeiting that or taking advantage of it and using that.
There's another point in the motions we'll get to that actually
Yes.
addresses that, and same with the manufactured product. So also for public comment, this one was really about the QR code and just the sticker. There's 4 more motions coming. That's why we split it up. now.
And just for further understanding of, in general, is each county, city, who's responsible for petitioning that framework?
So the cities and the county programs are more of a designation of origin program. So when we think of an appellation, we think of a unique geographical region, right? So it's not necessarily defined, although it may be, but it's not necessarily defined by political boundaries.
Correct.
It's generally defined by geographical features. So think of a watershed and the uniqueness of, say, a small watershed. It might have unique flora, fauna, soil types, climate expression. And so this is really generally a smaller subset of a local jurisdiction.
To be like a mountainside.
No, it makes total sense. I guess what I'm concerned with is how do you protect certain producers or someone eliminating other people within that same appellation from, like, if you say it has to be 100% grown, produced, manufactured here, with another producer doesn't have the same framework or operational setup as yourself, how do we protect that from becoming the next fight?
Right.
People trying to bring.
All of those pieces are wrapped up in the CDFA regulations. Yeah, and really there's a lot of work that goes into just establishing a petition, because the petition itself, which is what the producers of a hopeful appellation region will create, is going to include geographical identifiers, right? So the geographical boundaries of the region. It's going to include some information that helps CDFA and eventually, the reader of the petition understand why there might be a unique or distinctive quality to the cannabis grown in that region. So it might include climate factors, unique soil factors, unique geographical factors that might influence the very adaptable cannabis plant.
Thank you. Do we have a second on the motion? Well, we did, so we were going to put it to vote, please.
So we're ready for a vote?
Yes.
All right, Member Bauer. Dr. Brown? Member Brown? Member Christensen? Member Clifford? Member De La Rosa? Member Frazier?
Aye.
Member Polson?
Aye.
Member Shockley?
Aye.
Member Tupy? Oops. Member Woolsey?
Aye.
Vice Chair Nevedal?
Aye.
And Chairman Jamalian.
Aye.
Motion passes.
Thank you.
Thank you. So we'll move on to the next item, which is a motion to recommend that DCC adopt regulations for labeling requirements to require the appellation name followed by the term appellation on the primary panel of the label for non-manufactured products. And then for manufactured products, the recommendation is to include the phrase "made with," followed by the appellation, and then the term appellation. And this would also appear on the primary panel for manufactured products. So,
Members, any questions? I think there's probably more regarding manufacturing. I'm a manufacturer. I have a few questions myself too, so I'm sure everyone does. So floor is open if you guys want to. I think you were already going down the manufacturing route, so if you want to continue, this is.
I don't have any particular questions at the top of my head at the moment. I think Member Brown.
I'm curious if we want to address anything that was mentioned by Janine Coleman as far as the not engaging with the manufacturing side of it, or not making it a current priority without further analysis and research.
well, I think this is definitely a substantial topic, right? And traditionally, if we were to look at wine appellations or food appellations, especially as they're terroir-based, and in the European model is where we see these primarily terroir-based appellations. Manufactured products aren't eligible for appellation because by the time you manufacture a product, say you make a cookie that has some champagne in it from the Champagne region, you would not be allowed to utilize the appellation name Champagne because the cookie itself and all of those additional ingredients essentially blocks the consumer from experiencing that unique quality that comes from that grape being grown and the way the sparkling wine is produced in that region. So when we were engaged with California Department of Food and Agriculture through the working groups for the development of this appellation of origin program, this was very much so kind of a hot topic. And there are some manufactured products that may express the fullness, say, of the whole cannabis itself, such as like a kief or maybe a water hash. But when we look at something like an isolate, right, an isolate is not going to express the unique characteristics of that cannabis grown in said appellation region. And this is where the concern is arising from. You know, the appellation of origin program offers, if rolled out in I think a thoughtful manner, really has an opportunity to offer cultivators in a multitude of regions a great opportunity for marketing and branding, but also that area potentially a great opportunity for agritourism, right? And so there's been a lot of desire and public comment around preserving that very traditional terroir-based components to appellation, and there's much concern that allowing labeling on manufactured products, you might lose some of those terroir-based components, right, based on the product. An edible, for example, is not going to offer you or the consumer the ability to experience the uniqueness of said region. So I think it's a very viable concern, a very real concern. But the regulations currently within CDFA, those CDFA regulations do allow for or include manufactured products in the program. But I don't know, I guess what I don't know is if there's enough wiggle room within those regulations to create wholly different or say perhaps disallow the labeling of appellation on manufactured products. That I am not clear on.
But from a workflow kind of point of view, a lot of the smaller outdoor farmers work with companies that do their trimming offsite, that take it to SoCal, they trim it, they bring it back. So there's also a whole, slew of adulteration potential in that when you go into a facility with a bunch of other farmers from other appellations, right? So I think you're going to face a problem where a Humboldt grower will have somebody do their trim and probably even produce their pre-rolls somewhere in SoCal and bring it back to them. So, and I'm sure that grower, especially if they went through the trouble of becoming part of this appellation program, will want that on their manufactured product. Or if I had a kitchen in my appellation and was making an edible that I grew the flower for myself, I'd probably still want my appellation on there as well. So I think we also have to think about what do the members want? How do they want to use the seal for their marketing purposes? It feels like the caller that called in is part of that community, and maybe holding off on the manufacturing would be the right thing to do, right?
Yeah, I mean, I think it is tricky because if we hold off on manufacturing labeling, right, which I'm absolutely not opposed to, I just want to be clear that there's cultivators, as long as the appellation petition as it was approved allowed a cultivator to utilize the services of a processor or manufacturer outside of the region, holding off on the manufacturing labeling would not stop the appellation developers from allowing that opportunity within, right? I mean, we're really strictly talking about the labeling component here, right? What can be on a label and what can be labeled as an appellation product. And so the question before us is, should manufactured products be allowed to utilize the appellation seal and the appellation label? And perhaps some, but perhaps not all of them, I think is
the hard answer here.
Yeah, I think it's a matter of rewording this motion. It's very granular and it even says where you place it with the primary label. So maybe it's really about rewording the motion and making it a little bit more general.
I'm curious, who can apply for a petition? Right.
Cultivators only.
So
And it's really, and let me just clarify, I apologize for interrupting you, Member
Yeah, sure,
Shockley, but it's for outdoor cultivators who are cultivating their cannabis in the ground without structures.
Yeah, and because I guess what we would want to avoid in this process is the system being gamed by large operators who just want that seal on their product, right? And so if a large operator can come and make a petition for appellation that allows for manufacturing to happen outside of that appellation, that seems like it would be a backdoor, right?
I mean, I think that the question is less about size and scale and more about whether or not the label should be utilized on products that may no longer have the unique characteristic of said appellation and unique expression. So again, if we looked at something like a water hash, which is basically like a stripping of the trichomes from that plant, that's going to have it's likely to have the unique expression of that region, right? But when we go into more chemical or solvent-based extractions, we stand the risk of losing that uniqueness of the cannabis, which is really wrapped up in the petition. So the petition has to show, right, that there's a unique quality or characteristic based on the region where that cannabis is produced. So non-manufactured products are going to hold that uniqueness across the board, right? But manufactured products and then multiple ingredient products, right? We start losing those unique characteristics. So at what layer?
I'm following that, but I think
It comes from it's same as wine, right? But you can still be an incredibly large commercial winemaker and have an appellation. And that's the same thing here. It's not going to stop a glass house from getting an appellation as long as they fit as long as they grow it in the ground. And that's part of the game. It has to be fair for everybody, right?
Yeah, I don't know if that's an apt comparison though, because wine is just.
That's exactly where it's from.
Wine is only delivered in a liquid form, where cannabis.
But you taste the terroir. If certain appellations, especially in Napa, if you like Coombsville, taste different than Atlas Peak. They really taste different because they have different sulfur and different,
And some wines are blended and some.
Right. Yeah. And then
I'm of the opinion it probably needs more.
Oh no, I don't disagree with that. But the appellation concept is what I'm referring to. Please.
If we were to particularly reword the second part of the motion, right?
Yes.
Then what are the other options?
I mean, what we could do is we could potentially eliminate the second portion of the motion. And we could clarify in the first portion of the motion that it is for non-manufactured products solely.
And so you seem to suggest, though, that regardless of what we do or suggest about labeling, there's still another process that's going to continue regardless of what the labeling does. Can you say a little bit more about that?
Can you expand on your question, please?
Sure.
Because the program is through CDF.
Yeah, the CDFA
So
appellation.
this is a program exterior of this whole conversation, essentially.
Right, so all we're talking about is labeling.
Yeah, a concept for labeling parameters,
Right.
that's it.
And so a manufacturer might still have under CDFA rules the appellation of origin, is that correct? But they might not get the label if
A manufacturer cannot apply for an appellation of origin. A processor cannot apply. It's only cultivators. And the petition process is very detailed and thorough. And it's a matter of, identifying your geographical regions, the uniqueness of that region, but also working with the farmers in that region to come to agreement so that that petition moves through without objection, right? So there's a lot of community organizing that's going to go on as folks are developing these appellations. And so The petition then, once developed, is going to go to CDFA for review. The public has an opportunity to be made aware that an appellation petition has been submitted, that it's complete, and that the CDFA is considering approving it. So it has a public comment period at CDFA. And then barring, I would think, significant discourse over the development of said appellation, the appellation would be approved, and then there would be a public notice that the appellation had been approved and that there was now an appellation formed in said name.
So if there was a situation where the appellation is approved, but there's no labeling, because I understand DCC is also involved with labels. So then could it be that the manufacturer might have the ability to say that they have an appellation of origin, but then they don't have the label itself? Is that?
I don't think so. I think what we're looking at today is that exactly, right? So how does the labeling work on these final form products and on which final form products, right? And so this, I think, is ultimately the question at hand. I don't think there's any contention around non-manufactured products, but if we look at the purest appellations and, terroir as a whole, across the board, manufactured and multiple ingredient products would not be included in internationally recognized appellation of origin programs.
Would it would just make sense to take that language and make sure that the two of them are compliant with one another, right?
Yeah, I think that that's the desire of the cultivators who participated in the working group. And I think Member Woolsey, you had a question?
Yeah, what's the need for the regulation? Is having, if I had Dave's Mountain as an appellation, and am I not allowed to put that on a label now? And so this is a recommendation to allow for that, or is it to standardize? If I'm calling myself Dave's Mountain Cannabis, it would be Dave's Mountain Appellation Cannabis, and that would standardize that my appellation, your appellation, somebody else's appellation are legitimate, and someone else who's like, oh, Dave's Mountain Cookie is not, because it doesn't have the right word on
Right.
it.
So there is another recommendation here that acts to address some of this. But the idea is that if Dave's Mountain Cannabis was developed before that Dave's Mountain region created an appellation, that the appellation would disallow Dave's Mountain Cannabis to utilize that name unless Dave's Mountain Cannabis, right, the original Dave's Mountain Cannabis, was part of the appellation and adhering to all standards set forth by that appellation.
Okay, I think I'm tracking.
And I mean, as it stands right now, the regulation says you cannot say that a product was made somewhere unless all of the material inside there was from that from that place. So like, we can't put San Francisco indoor on our packaging unless it is all in metric tracked to a San Francisco cultivator, right? So I think there is a lot of mechanisms in place already that there's a framework within metric within the system that would allow this to be implemented as well.
And this would
And
be an
enforced.
additional burden on label people who have to put a bunch of stuff on labels already.
Well, these people are opting in, right? It's voluntary. You're opting into it.
Yep.
You want to put it on at that point.
It's voluntary. So if I'm a cultivator in Dave's Mountain Cannabis or appellation, right? So
Point.
say I'm a cultivator in Dave's Mountain appellation, I don't have to adhere to the standards of that appellation, but it means that I cannot label my product as Dave's Mountain Cannabis, okay? And it is also possible that as a cultivator in Dave's Mountain Cannabis region, I want to cultivate some of my cannabis outdoors in the ground and adhere to those standards. And some of it I might want to, cultivate in a mixed light setting. So I may have a portion of my cultivation site that is recognized and eligible to wear the appellation of origin seal, and a portion of it that simply is not. And that would be all right as well. That would totally work within the regulations.
Thank you.
To go back to your motion, what you said you would just eliminate the last part. Is that
So we could, if I may, you want me to?
Please go
make
ahead.
a suggestion? So what we could opt to do is amendment to this motion that read something along the lines of this. Recommend that the DCC adopt regulations for labeling non-manufactured cannabis to require the appellation name followed by the term appellation on the primary panel of the label. I think we could just stop there.
If I may suggest removing on the primary panel and just label. I think it's just too granular, too burdensome. It's not an official warning symbol or a weight, and the primary label really requires what type of product is it, what's the weight, warning symbol. So I don't think it carries the same weight.
So the reason why we opted for primary label is to try to keep this as simple and analogous to how appellations are labeled in other sectors, especially the alcohol sector. So if we look at wine, all labeling is exactly the same, right? You have the brand name of the wine, and then underneath it, if it's produced within an AVA, you have that AVA name, right? So the idea here by requiring it on the primary panel is that it will always appear in the same place for the consumer to readily recognize what they're seeing and where to look for it, right? And then on the secondary panel, which is, usually like the back label, this is also where we have the license information, so the license holders information, and there was concern that it could be confusing having the appellation name on the same area as the producer.
I'm saying
right?
anywhere on the label, just don't make it a primary label requirement. It takes away from the member or the appellation owner's creativity, how he or she can design their packaging. It's very limiting. I wouldn't.
That was the point, was to
Yeah,
have it be
it's
very
consistency
limiting.
for
It's
the consumer.
consistency for the consumer. So
I
it
understand
always
that.
looks the same.
I don't think it carries the weight of a warning. I don't think the DCC is required to help with marketing.
Fair enough.
It's a regulatory body. It's not a marketing body.
And I think that anyone taking advantage of the appellation program is going to want it front and center.
Exactly.
They're going to make that effort. And we kind of talked about this the other day and went back and forth on it a little bit, but I do, I was concerned about getting into too much of the details of, a font or a text or a size and valuing the artistic side of marketing and advertising. A lot of the labels are art pieces,
Yes.
And so.
And the QR code already addresses the
tamper-proof.
Well, yeah, the tamper-proof QR code is what proves that it's real, right? Isn't that the counterfeit part?
Yes, I mean, we see in traditional appellations, the tamper-resistant seal is very traditional, especially in European regulations and elsewhere. But the labeling is always consistent. The name of the appellation always appears in the same place on those labels.
We're not European winemakers. We're California weed growers.
We might be California cannabis growers, but the idea here is to build a program that has longevity and has the ability to pass muster as an internationally recognized product and have simplicity in the marketplace. And I think that's really important.
Could be good for preparing for federal legalization as well.
Yep, exactly. Because trying to do this over later is really challenging. And this is a lesson we learned from wine producers, right? When we had a lot of conversation with CDFA in the working groups, we also heard from a number of AVA members. And the AVA does not have a terroir-based program. It's not a appellation of origin program. It's more of a designation of origin program, similar to our county of origin or city of origin programs for cannabis. And it has been somewhat contentious, right? Should the AVA program morph more into a terroir-based program with standards that will hold that value on an international level? Or should it stay as an AVA program? And so I think the lessons to learn here is it's going to be very hard to go back if we are feeling challenged by international standards down the road, right? So how do we set ourselves up for success out the gate with a program that hopefully will stand the test of time and be comparable to international standards as we see federal legalization occur and an international marketplace exist?
And bear in mind, these are just recommendations. They're not necessarily
Yeah.
guaranteed to happen at all.
And the primary label location would only affect people who are putting an appellation on their label, right? So anybody who's
Correct.
not ignores that.
Correct.
With that, do we have a second on the motion?
And so let's make sure that we understand what the motion is. Yes, so is it?
Reworded.
So the reworded motion, if I may, would be to recommend that DCC adopt regulations for labeling non-manufactured cannabis to require the appellation name followed by the term appellation on the primary panel of the label. And you'll second. Thank you.
With that, can we go to public comment, please?
Yes, we will go to public comment, and I'm going to reread that really quick, just so I know I have it.
Thank you.
Recommend the DCC adopt regulations for labeling non-manufactured cannabis goods requirements to require the appellation name followed by the term appellation on the primary panel of the label.
Correct. Thank you. I think they will. It's an educational program. There will have to be some education around it. And the QR code will drive them back to CDFA's website, which will have some further explanation and also access to each approved appellation standards and regional identifiers.
All right, so we're going to open this motion up to public comment, and first up is Janine Coleman. I've just sent you a request to unmute.
Thank you so much. Janine Coleman, Origins Council. We want to express our very strong support for the amended recommendation and really deeply appreciate the conversation and the nuances and depth of the discussion, and want to express my appreciation to Vice Chair Nevedal for lending her depth of experience to the discussion. So thank you very much. Strong support.
Thank you. Are there any other comments, either in person or, oh, yes, there is.
So I do think an important point was brought up with the primary label aspect. Because somebody is going out to apply for this, indeed, it'll probably end up on the primary label in all likelihood. And also with the appellation thing, I am the general manager of a dispensary in Sonoma, and I hate to say it, I didn't know what appellation was until we start. I caught on to it. For me, I drink coffee, it's single origin. That's how I see it. And so there is going to be different terminologies, and that's partially what I was going to ask about is, you know, there's lots, that's what I meant by kind of micro and macro. There's lots of different terminologies for it. And I'm just curious, what language, is there going to be an umbrella language, or is there going to be specific terms like appellation we have to use, which I am learning today myself. Quite frankly, I dictionaried it. And then also on that creative end, you know, I look at the coffee industry once again. There is no requirements in regards to where that origin has to be. Sometimes it's on the side, sometimes it's on the back with a story to engage you. And sometimes they even have it hidden, so that way the idea is you consume it and the connoisseur can try to guess where it's from, in fact, without it just being directly put in their face. So there's just lots of creative routes you could go with that. And since the person's applying for it, I think we should give them the creativity to apply that as they please, in my opinion.
Thank you.
Thank you. All right, we have Jason Sharouche. I've just sent you a request to unmute.
Jason Sarouche from the Public Health Institute, although I'm speaking not on behalf of that organization. I'm a registered dietitian, and a lot of the labeling claims for food have been to do with appellation claims. I think it's really important to allow the manufacturer to decide where to put those. Just like the previous commenter said, not always on the primary panel of the label. And there's a lot of other information that should get that limited real estate that's there. Recommending the DCC allows it to be part of the primary panel is important, but a requirement that it's there is unnecessary, and it's could be more burdensome, especially for smaller products. The second thing I want to bring up is, why should this only apply to non-manufactured products? If a product is manufactured from cannabis from a specific region, that product should still be able to make that appellation claim, given all the cannabis used in that product is from that place. And building on that, if it's a blend of different products, different types of cannabis that are from different places, they should be able to mention where those specific types of cannabis were grown and make those appellation claims so people know what they're getting. Thank you so much.
Thank you. All right, Diana, I just sent you a request to unmute.
Nevada County Cannabis Alliance, and on behalf of our small farmers here in Nevada County, we also support the recommendations being put forth today, and thank you for the care and attention and thoughtfulness in which they were constructed.
All right, at this time, we have no other comments either in person or online for this particular motion.
Thank you. Can we get a vote, please?
Yes, and I'd ask each of the members to speak clearly and close to the microphone. There's a little bit of feedback, so if you could clearly state aye or nay in the microphone, I'd appreciate it. So starting off with Member Bauer. Dr. Brown.
Aye.
Member Brown.
Aye.
Member Christensen.
Aye.
Member De La Rosa. Member Frazier.
Aye.
Member Paulson.
Aye.
Member Shockley.
Aye.
Member Woolsey.
Aye.
Vice Chair Nevedal.
Aye.
And Chair Jamalian.
Nay.
Looks like the motion passes.
Thank you. Moving on to motion number 3.
Great, thank you. So motion 3 is to request that the DCC adopt 1 year as the appropriate transition time for businesses that do not meet the appellation of origin requirements. And so, we talked about this a little bit earlier. It just really is a timeline that allows a business who has established a brand in a name that then becomes an appellation to unwind that brand name, so to speak, unless, of course, they're within the appellation and adhering to said appellation standards.
Does this amount to essentially a grace period for a manufacturer or a grower of a product to change their brand, and then they wouldn't be cited for misusing the appellation during this time frame? Is that the intent?
I believe that that is the intent, yes. So it would be, if I created Dave's Mountain Cannabis and you had Dave's Mountain Cannabis brand, you wouldn't be cited 24 hours after the appellation was publicly approved. So.
Okay. The question for the people who deal with labels is 12 months. Does it take that long to use up labels that I might have already purchased and then purchase new labels with?
I think it's a bigger question of rebranding.
Or
How long
rebranding?
it takes to build a brand, and then somebody just applies for an appellation. You have to all come to an agreement, right? If you're all in the same appellation, you all have to come to agreement. Now, you had that brand for 5 years, and your neighbor moved in 2 years ago, but really wants to join this appellation program. How would you feel about that? I think this is just a lot of lawsuits waiting to happen. Trademark infringement. I mean, what if somebody trademarked Dave's?
Right, but
I mean, have we?
which isn't my own actual brand, by the way.
But it will be after this meeting.
I didn't want to pick or focus people on one particular actual brand, so I'm like, I'll just mix it
That's
up.
great. You coined it.
But while that's probably true, I think the broader question is, what's an appropriate time frame, right?
Right.
How long should people be allowed to continue using something that they've already been using before they have to, switch, before they're forced to switch or could be cited for using it inappropriately? And to me, 12 months sounds long at first, but then when I'm thinking, if I already have 10,000 labels somewhere and it takes me a year to go through those, and I don't want to have to buy 10,000 more right away, but then 2 years seems too long, so.
Yeah.
Is there discussion on, like, how did you settle on 12?
Well, going back to the working groups with CDFA, this was in the general consensus for the most part, that 12 months would be adequate, and an appropriate timeline for that transition. And so, we did discuss other timelines, but 12 months was definitely the consensus amongst working group members. And in general, we look at appellation programs, they do supersede established trademarks.
They do? And who
They do.
enforces it?
WIPO, and then the Lisbon Treaty. So there's those enforcement groups, but really it's upon the appellation in most cases to get that ball rolling.
Okay.
So
it's infringement.
It
The
is an
appellation would then accuse Dave of infringing on the appellation and would get a cease and desist. Sort of what the big corporates do right now with all of us little guys.
All right, thank you.
I have a question. So regarding the CDFA regulations, was there any thought or consideration to any of the existing brands? Was there any sort of strategy in the development of those regulations to take existing branding under consideration?
Oh, well, yes. I mean, we had robust conversation about the transition period, how long it should be, that there should be one. And I mean, I believe that was in the regulations originally. And then when we saw the agencies merge and CDFA maintain the appellation of origin program, the original language around timelines for phasing out was stricken because the labeling requirements came with DCC and the program essentially stayed with CDFA. So 12 months is what was originally in place, and then there was the merger. So now we're readdressing that question.
Thank you. That's helpful, but I think I wasn't clear. I really meant more along the lines of like selecting the name of the appellation. Is there any consideration given to already existing brands when you're putting in a proposal saying, I would like to create Dave's Mountain appellation?
Well,
Has Dave been
yes
talking?
and no.
Is it
Yes
vetted?
and no, because there's requirements within the CDFA regulation to show that there's some historical name use, right? So for example, there are multiple salmon creeks within California, right? And that's just a known. However, Salmon Creek in southern Humboldt has had name brand recognition of cannabis from that region dating back to the 70s. So, if someone created Salmon Creek cannabis and they're not from that region, it's a little tricky in the reverse, right? Because it's just like, we wouldn't want to, when we think of the county or the city of origin, there's Humboldt Road and Humboldt in lots of different kind of geographical contexts. But when we think of Humboldt in relationship to cannabis, there's historical usage because of the county of Humboldt and the long, robust history of cultivation there. So it's upon the petitioners for the appellation to show that there's a historical name use associated with the name they're choosing. So if they don't have Dave's Mountain, if they aren't known as Dave's Mountain in that region, it's going to be hard for them, I believe, to actually get an appellation in the name of Dave's Mountain. So I don't think we run the risk of, say, appellation of origin petitioners going after big brand names unless they can show that that really is a name that's historically associated with the cannabis produced in that region.
It actually seems more likely to be the other way around, right? Where a
Yeah.
company would want to
Yeah.
affiliate with, okay.
Yeah.
But what if there's 3 people in that appellation and one of them had the brand and he doesn't want to join? That's really that's where my concern comes from.
Well,
He's the guy.
And he's the guy that's established the whole
name.
thing, and he's probably the less likely one to want to share that
well,
appellation.
that appellation might not move forward.
Okay.
So, I mean, if that brand within said region opposes or objects to that petition as it goes through CDFA, that's a consideration CDFA will have to take, they'll have to consider that.
I think we need some more education around the CDFA process, because everything comes back to the CDFA. We have these motions and every time we need to put them in context is with the
Right.
CDFA process. So yeah, maybe a presentation or like a summary of that next time would probably help
Yeah, I think that
with meeting materials.
it probably would help, absolutely. But the program has been, frankly, a very long time coming, right? We saw regulations passed in 2020. They were then amended in 2021 when we saw the merger of the agencies. Petitions were supposed to be available for submission, I believe in 2021 or 2022. They still haven't opened that up. So this is, I believe, kind of the last caveat of regulatory development needed for this program to actually become available. And, a transition time, I think, needs to be in place, right? It was a consideration all the way through the development of the CDFA regulations. It was set at 1 year, and then because it's in relationship specifically to the labeling, it got stricken when the agencies merged, and now we're having the conversation again after much input from stakeholders, cultivators, and the public, which had established the 1 year originally.
If I understand correctly, the program that gets you an appellation, that's already said and done, and we're just trying to now catch up and apply. How do we label that into the DCC's regulatory scheme appropriately?
Correct.
Thank you.
So I worked on wine labeling policy in the early 2000s, and I will say it does not get easier if you just push it off. It becomes much harder. It happened many years, and it determined the composition of where the grapes were grown. And there was a 3-year period where we allowed, because they're the same issue. We had brands that were based around that had the name of the appellation and the brand, and then they had to transition. And I would say we could learn something from that, and that I don't think pushing this off longer is going to make this any easier, because it's much harder when there are more established brands, especially when you can see consolidation in the industry. So I would just recommend that we move something forward. Again, it's just a.
Do you think 12 months are enough from your experience?
I think early labeling happened in the 90s. We did some regulation, and that was like 20 years. So I would say 1 year sounds right. But again, I'm not from the industry, so I defer to you all. But I would say it is challenging if we wait any longer.
I'd like to add too, I think the 1 year also came from the typical shelf life of a lot of cannabis products, or even strains. If they're flowers, some of them are only lasting a year, things like stuff like that.
Sure, but packaging, often you buy bulk for, a whole year, not more than that. So I think a year is probably pretty good. So do we have a second on the motion?
I'll second.
Thank you. Can we open for public comment?
We sure can. We are on motion number 3, open for public comment. And Janine, I've just sent you a request to unmute.
Thank you so much, Janine Coleman with Origins Council. We support this recommendation and again, really appreciate the conversation. We would further recommend the regulation for effective dates allow for the 1 year sunset period only for geographic brands that were in use before February 21st, 2020, when the first CDFA notice of proposed rulemaking for the Cannabis Appellations Program was published. And we want to appreciate again the background information and emphasize that this recommendation is based on 2 years of CDFA rulemaking and 5 successive regulatory packages for the Appellations Program. And it, as Vice Chair Nevedal stated, it was only removed from the CDFA regulatory package due to agency purview considerations pursuant to agency consolidation, the formation of the DCC. This policy was vetted legally by CDFA's legal team over the course of those 2 years, and it's based on case law in wine. Excellent considerations that you brought forward, Chair Jamalian, regarding trademark considerations. It has been deeply legally vetted. There was also expert legal input in the CDFA Appellations Working Group, and all through the regulatory process subsequent to promulgation. It is a time-sensitive consideration. Really, this is an urgent need, frankly, because it having a lack of clarity and regulation for all of this time has created a situation where there can be a rush on trademarks for geographic brand names, and that can become a
30
very,
seconds.
very significant situation for undermining the integrity of the program as a whole. And this issue really strikes at the heart of appellations as truth in labeling laws. So we very much support the one-year transition timeline and really appreciate your consideration. And again, we want to emphasize that in order to protect against a rush to register geographic trademarks that do conflict with potential appellations, this one-year transition should only apply to geographic brands that were in use before February 21st, 2020. Thank you so much.
Thank you. Are there any more comments for motion number 3? Nope. So comment period for motion number 3 is concluded.
Thank you. Can we get a vote, please?
Yes. All right, Member Bauer? Dr. Brown?
Aye.
Member Brown?
Aye.
Member Christensen?
Aye.
Member De La Rosa? Member Frazier?
Aye.
Member Polson?
Aye.
Member Shockley?
Aye.
Member Woolsey?
Aye.
Vice Chair Nevedall?
Aye.
And Chair Jamalian?
Aye.
And the motion passes.
Okay, going on to motion 4. Motion 4 is to ask the DCC to develop different penalties for the misuse of the appellation name or seal and for counterfeit seals. Both shall be no less than $500. So a little background, currently mislabeling is a penalty of $100 to $500. We heard quite a bit of public comment and concern expressed that a $100 to $500 penalty was likely not adequate and potentially could be treated as a cost of doing business for folks who chose to utilize an appellation name without being part of the appellation and or actually having an approved appellation. So the idea here was to establish a higher floor for penalties, but then encourage a tiering of penalties so that there would say misuse might be $500 as an example, but counterfeiting a seal might be a higher or heftier violation and penalty. So that was the idea behind this motion that we're discussing currently.
I have to take issue with one thing. What penalty is $150 for mislabeling? Can we get input from the DCC here? Because I've never heard of this penalty.
Like, I think this is coming from the way our disciplinary guidelines are set up, which the disciplinary guidelines are used for license revocations of an annual license, a suspension, or to issue fines under that process. And so in our guidelines, there's a number of criteria we take into consideration, including like prior acts, the whole of it. And then you look at if there were other violations with it that could increase penalties and stuff. So there's like all those factors that you take into consideration. So even if like the general guideline says that this like type of violation, we generally say that's a minor violation and equals this amount, it could still change. So depending on the facts and circumstances, it could actually be a major violation or something like that. And then the other thing is our disciplinary guidelines, if you read them on the first page or something, it says like what they apply to. They don't apply to citations, which are a separate thing that we can issue, and those are determined under statute. And there are factors there too, kind of similar to what you consider, and it's like 5,000 up to 5,000 per violation for licensees, and that's also the same section that has the up to 30,000 per violation for unlicensed.
But I think it's important to note that those violations are not related to counterfeiting a logo or anything like that. Because we're asking them to enforce something that they don't traditionally enforce, which is the counterfeiting of a seal. And I just don't understand this this fee structure, the fee structure, that you're introducing, because that's not something that's typically.
So maybe I can bridge that a moment, because I think when we think of counterfeits, we think of what's happening in the illicit, unregulated marketplace,
No,
right?
I'm just talking about enforcing the counterfeiting of a voluntary appellations program with by the DCC. I
And
don't-
500 is too high of a penalty or not enough?
No, we don't, the DCC doesn't have this kind of penalty structure. So just to introduce a completely different new penalty structure for a very limited amount of appellation permits it's creating a really big system for something that should be administered where the workflow currently sees that. So these things are label claims. Label claims are typically the distributor or the lab has to verify those. This is not something that the DCC should be doing. This is something where in our chain of custody, there are two places already where your label and your claim is verified. And there's no $500 penalty. It gets locked out of metric and you can remediate it. And you make a remediation plan and you submit that to the DCC. And if it gets approved, it gets unlocked. That's the mechanism for this. That's all I'm saying. To start a whole separate, workflow or entity or whatever that needs to be within the DCC to look at the appellation program, which is a marketing tool. I just don't think that's the right use of the resources here at all.
I think the background was that we had been poised with any additional recommendations for more regulations within the DCC program to help ensure the success of the appellation.
I understand, but our industry right now as a whole is hurting across California. The DCC can't pick out one region that they want to help more than another region. That's just not, I feel like there's a lot of conflict of interest there. That's my opinion. I'm not even sure it's right. There's somebody who can definitely educate me on that sitting next to me. It's just, this is already really heavily marketing tool. I think we're already going down a really slippery slope here, which is fine because there's apparently precedent with the wine industry and the CDFA has obviously vetted this. Cool, get your appellation. But I don't think the wine industry has the ABC enforce their appellation programs.
But I will say with labeling, sorry, just, I don't know if it's off topic, but the THC percentage has become a marketing tool. There's lawsuits out there saying that's not true.
Sure.
And it's been proven. So I would say maybe the THC should have a stronger type of enforcement.
But that's again, that falls on the lab. That falls on the lab and the distributor. If the lab is tested, if the lab is willing to overstate, then the DCC has their means to enforce against labs.
But a judge just declared that the people, that the labelers are responsible, even though it's third-party information, it just declared they are responsible for that lab information by using labs they know are willing to falsify data. So that's still coming down the line. And I guess all I'm trying to say is that I would, in my mind, we're trying to find ways to help California, to help the growers, the legacy people stay here, have an opportunity to participate. And I see this as benefiting towards that. Because if you have someone that is using, let's get more real, Sonoma, Emerald Triangle, whatever it may be, improperly, they shouldn't be allowed to, in my mind, if it's hurting the people that they say are.
I agree, but just like they said, it's up to the appellation to go after that infringement. That's the same exact thing. It's an infringement. It's the exact same thing. You're infringing on their trademark, and then it's up to them to go after it. I'm just trying to deny content.
No, you weren't good. I just had a thought. I mean, I would love for there to be an equity seal, for example.
Yeah, we made our own, for example, because just
and so, but to your point about the fairness or about focusing on, it's something that is beneficial to the appellations, but is it something that other seals could benefit from, or is it specifically just?
I mean, in this context, in today's conversation, it's specific to appellation, but I totally agree with you that there could be more robust labeling, misuse of labeling penalties. I do believe that when the CDFA regulations were originally finalized, there was an infraction section in those original rules that had to do specifically with the misuse of an appellation seal, and there were fines associated with that. Again, every component related to labeling in that original rulemaking packet, right, approved rulemaking packet, the entire labeling and all of the penalties associated with it were stripped from that packet when the agencies merged. So it's my recollection that there has always been the intention to have a fine associated with the misuse of an appellation. And so this is why the question, I believe, was brought forward by the DCC in this context.
Do we know why they took that out of when they did the?
They took it out simply because the Department of Cannabis Control maintained the purview for the labeling of all cannabis and cannabis products when they were formed. Okay, so originally the labeling was broken into each kind of regulatory agency's
CDPH,
purview. Exactly. So CDPH had manufacturing, and California Department of Food and Agriculture had non-manufactured products because they had the cultivators and the processors under their purview. But now all labeling got put into the purview of Department of Cannabis Control, including labeling in relationship to city or county of origin and this appellation of origin program today. So I think, what we're looking to do is kind of capture some of what was originally in that final rulemaking packet that had, as Ms. Coleman stated, had many years of work behind it, 5 different turns of regulations, copious stakeholder input and public input. And so now we're trying to just provide guidance to DCC about how to proceed. And frankly, what feels most appropriate to me is to kind of continue that thread forward from where we were with that final rulemaking packet.
And because of that, I keep saying there are mechanisms within the DCC already where on label claims from a distributor or lab, if it's not real, they can lock it out. There is a mechanism. It would just be part of your label claim that I am from this appellation. Just like you say, there's 3.5 grams in there. If it's less and they weigh it out and it's 2, they're going to lock your product out.
It seems to me like it's definitely necessary, specifically for the appellations, but it might be more appropriate to create a regulation that applies to all packaging, and that would incorporate,
We already have that.
as well.
That's the label claim. That's what we.
It sounds like it wasn't carried over when the 2 agencies were consolidated for the purpose of the new agency has to regulate all labeling, right?
Currently, label claims are still, like when I submit a pre-roll label to my lab or a pre-roll, it's labeled, it says the weight on it. They weigh it to make sure that there's not more than a 10% deviation on the weight. They test it if you had it R&D tested before and you have a result on it, they test it again to make sure that you're not within 10%. So everything you claim is inside of your product on the label is currently verified by the lab. We have a perfectly functioning
But does
workflow
it
this.
check
this
for
would just have to
counterfeit?
be added.
Did the
No,
lab?
that's my point. The counterfeit part, that can't be up to the lab or the DCC to look because they're not the owners of the.
Well, we could maybe could be by the DCC.
Yeah.
It just needs to be across the board, just not for one.
I mean, I think what we're talking about here is unique, right? Because we're asking the DCC to consider issuing a secured seal for appellation of origin products specifically. So the DCC will be, if this were to be implemented, right, the creator of the appellation of origins tamper-resistant seal, and they would be the provider of that seal. So if there were counterfeit seals, I think it would be in their wheelhouse to enforce, the fact that,
And counterfeiting a seal is kind of a big deal.
yeah.
So I would support the addition of fines in addition to the locking down of whatever it is, because maybe that's not enough to deter people from misusing the appellation or going out and buying counterfeit seals. So to that extent, I appreciate the conversation I've heard so far, but when it comes to you're misusing something that, assuming this regulation were to be passed, if someone were to misuse that or worse, counterfeit it to try to bypass that, having a fine structure in place that is less nebulous so that you know if you do it, it's $500 a package. I don't know. Then
Is that gonna
that's
turn someone off that will go through the trouble of faking or stealing a seal?
If-
A
it
government
might.
seal, $500? All right.
per package?
Okay.
Yeah.
You know, and that's the thing is that any fine would have to be big enough to be not just the cost of doing business, because if it was a $1 fine, I'll do it all day, right?
Then we should just fit it into the current fine and penalty structure.
And if
That's
there
all.
is a current fine and penalty structure that it fits into, maybe that's the fix, right? We just slip it into a fine of a max of 1,000 for misuse. But I would go over that for counterfeiting, because I think that's a worse, that shows a more mischievous intent. So in my opinion.
No, I agree.
I want to chime in on like the CDFA's role in this, though. If they're the ones approving the appellation, do they also have a role to be playing in the leveraging of fines in terms of people who are posing as as an appellation that would be false? And is there room for us to, we don't weigh in on CDFA, I understand that, but is there room for us to recommend to DCC to work with CDFA to take that under consideration within their fee structure because it's not just the manufacturing of false seals, it's also if I am a cultivator and I decide that I want to adopt the label of an already established appellation, but I'm not, I'm like 30 miles away, somebody should be able to weigh in on that.
I mean, it's tricky. I don't disagree with you, right? I think there's the conversation we had on Tuesday, it sounded like there's the potential for DCC, and please correct me if I'm wrong, to issue a $100 to $500 fine for the misuse of an appellation name or the misusing a label. And what we heard from public comment repeatedly was that threshold of $100 to $500 was likely not enough and could easily equate to the cost of doing business. And so what we opted to do in this recommendation was make the 500 not a ceiling, but a floor. And then recommend that there be some tiering for more serious violations. So.
And this is per package though, right?
I think that it's not that specific currently. Why we're recommending a minimum violation of $500 and that there be consideration about the level of misuse, right? We recognized when we were having the conversation on Tuesday that counterfeiting, right, a secure seal for appellation of origin is a much higher level of violation than, say, accidentally commingling your mixed light cultivation into your outdoor cultivation that is wearing the appellation seal, right? So it can look like so many different things, which is why we kind of stuck with this recommendation of a $500 floor and requesting that there be some tiering. So more egregious violations or misuse can be handled with a higher fine than just a one-off oops, say.
Right. And just to clarify about the cost of business calculation, I mean, with wine, my understanding is that the real cost of business calculation is the lawsuit that you might incur if by the appellation itself, by the producers, right? Not necessarily a fine that would come into play. So are we trying to do something with a fine that actually should maybe be handled civically?
I mean, I think this is Chair Jamalian's questions in some extent. I think it can look like a number of things, but again, if we go back to the original approved package, there were a whole range of fines associated with misuse of an appellation's name that were anywhere from minor to serious. And those fines, because they're related to labeling, which is where we see the name expressed, right, of the appellation in a public-facing setting, there were fines associated with marketing. There were fines associated with labeling, right? We lost those pieces when the agencies merged, and arguably the labeling of cannabis and cannabis products is the purview of Department of Cannabis Control and not the purview of California Department of Food and Agriculture today.
But they must have had a fee structure in place, a penalty structure, because they were the ones enforcing appellations. Can we just see what they did and just use that as a blueprint?
I mean, we could go back and just ask that the DCC adopt the original penalty structure that was in the approved package prior to the merger of the agencies.
Was that a good one? Was that one where everybody sort of agreed on, or would that be outdated at this point?
I don't necessarily think it would be outdated at this point. I mean, the program hasn't launched because it's been complex and we've seen these, the merger of the agencies, but I don't know why we couldn't look back at that.
I mean, it's your motion. You please word it as you please. I just wanted more clarity on it and who's in charge. And I mean, if the DCC develops the seal, it makes sense that they would enforce it. Sure.
Mhm.
But I also think it's a stretch to ask the DCC to develop it unless they've already committed to it. But I don't.
Well, what we're also asking is that the DCC create regulations around labeling. So if they create regulations around how and where an appellation name will be utilized on a cannabis product, it seems to me that they would also be the ones enforcing the misuse of that regulation or that labeling regulation.
I agree with that.
But there's the Equity Trade Certification Network, for example.
Yeah.
That's a certification. That's a private, it's not an appellation, but it's a sort of a, banded together brands that do it. And the DCC wouldn't enforce that either, right? So I
But-
guess my question is what sets an appellation apart from a group of bona fide equity people?
Right.
that
Well,
they-
Yeah, basically.
Yeah, so the
Right.
appellation of origin program is in statute. So it's in statute. It was included in MRSA, and also I believe it was reflected or restated in Proposition 64. So it is in the Business and Profession Code as a codified program. Furthermore, a lot of the components of the appellation of origin program are within statute, including being cultivated outdoors and in the ground and without a structure. So these pieces make it a little different from, say, an independent certification, because those programs, those independent certifications are outside of the development of and purview of the agency because they are not codified in statute. So I think that's.
No, and I totally, by the way, agree with you. A huge difference. It should be like the appellations program, not you can just file a trade. Right. No, I agree. Okay. Well, in that case, do you want to put your motion as is, or do you want to?
I would like to leave the motion as is, please.
So we have a motion on the floor. Do we have a second?
I'll second.
Thank you. Can we open for public comment, please?
Certainly.
Thanks for explaining that.
Motion number 4 is open for public comment. And Janine, I've just sent you a request to unmute.
Thank you so much, Janine Coleman with Origins Council. Again, really appreciate the discussion and the care being taken by the committee on these issues. I just wanted to perhaps offer some clarification. The DCC does have a disciplinary guideline document which outlines existing, essentially categorization of penalties for labeling, packaging, marketing, and advertising violations. And so the original recommendations, the proposed regulations that CDFA was about to adopt categorize these violations as a serious fine. And that would be our recommendation as well, to categorize these violations in the case of appellations use. And we would also like to speak to the comprehensive and inclusive geographical indication system that California has, with also county of origin and city of origin. And we'd love to see, more efforts and support advancing those geographical indications as well. And all of those geographical indications, including appellation of origin, being categorized as serious fines with an opportunity for first-time offenses to accommodate a learning curve being categorized as moderate. I think as much of the discussion has really centered around, this really is about deterring abuse. And it was something that was, heavily
30
debated,
seconds.
discussed, and consensus with CDFA landed at that serious categorization. So really appreciate the discussion, and it really is about having that tool in regulation. And to your point, Chair Jamalian, the industry will need to be proactive about enforcement. So it's really about having that tool in law. Thank you so much.
Thank you.
Thank you. Thank you.
It's freezing in here.
Are there any more public comments, either in person or online, for motion number 4? Nope. So let's move on to motion number 5.
Vote.
Yeah, vote, please.
Excuse me. We will take a vote and then move to number 5. All right. So Member Bauer?
Aye.
Dr. Brown? Member Brown? Member Christensen?
Aye.
Member De La Rosa? Member Frazier? Member Paulson?
Aye.
Member Shockley?
Aye.
Member Woolsey?
Aye.
Chair Nevedall?
Aye.
And, excuse me, Vice Chair and Chair
Sorry.
Jamalian?
Aye.
Very good. Motion passes.
Okay, now we'll go on to the last recommendation here, which is motion 5. So motion 5 is recommending that the DCC require that each appellation of origin producer maintain a copy of the approved petition and public notice of approval on site at all times and make that paperwork readily available to the DCC for purposes of inspection. And this really is just if there's going to be labeling regulations, right? The inspector has to be able to identify whether or not that cultivator or entity is eligible to utilize that name. And so this is just a record-keeping request. So any questions or?
Yeah, floor is open for member discussion, but it's pretty straightforward. If it all falls under their purview, they should probably see the paperwork.
Yeah.
I don't think we probably need to discuss too much. Do we have a second on the motion? Thank you. Can we open for public comment, please?
Yes, we'll now open, motion number 5 is open for public comment. And Janine, I've just sent you a request to unmute.
Thank you, Janine Coleman, Origins Council. Very strong support for this recommendation. And again, just want to say thank you to all of you. Really have appreciated this discussion and excellent work, everyone. Thank you so much.
Thank you.
Are there any more comments on motion number 5? No.
Thank you. Can we get a vote on motion number 5?
You bet. Member Bauer? Member Brown?
Aye.
Member Brown? Member Christensen?
Aye.
Member Clifford? Oops. Member De La Rosa? Member Frazier?
Aye.
Member Paulson?
Aye.
Member Shockley?
Aye.
Member Woolsey?
Aye.
Vice Chair Nevedall? And Chair Jamalian?
Aye.
All right, motion passes.
Thank you. That concludes agenda item number 6. Moving on to agenda item number 7, Equity Subcommittee Member Shockley. Floor is all yours.
Yes, thank you. So just reporting back from our September 6th Equity Subcommittee meeting that we held, we had a great presentation by Deputy Director Eugene Hillsman about the DCC's efforts to, advance equity and inclusion around the state. He talked about their efforts to hold more engagement meetings with stakeholders from around the state to receive input. He talked about working with local municipalities and helping them with best practices around how to implement social equity programs, how they're making themselves available at the DCC to local municipalities who need support in starting their programs or help with any particular challenges they may be facing within that. So all that was welcome news. We also discussed one item that we were continuing from our previous meeting, which was around addressing the social equity definition and if there were changes or not any changes that we would like to make to the definition. We did take up a motion around addressing the definition, essentially changing one of the criteria for the definition to police reporting districts. And this was essentially about narrowing the criteria for qualifying for social equity.
Rather than the census tract.
Rather than the census tract. And if any other members of the subcommittee want to speak on that, please feel free to. We did vote in the affirmative to change that to police reporting districts. It is a conversation that we are going to continue further. There's a lot more we want to deliberate on in regards to the definition. So we will be bringing forward more recommendations on this topic in the future
And
as well.
those add more data sets, would they get more accurate? Is that sort of the goal of the subcommittee, to add more data sets to make it more accurate in determining who social equity applicants should be?
Essentially, yes. Essentially narrowing down, who qualifies for these benefits of social equity.
So I have a question. I'm not sure that anyone here has the answer to it, but I'll just pose it. With the police reporting districts, I guess I'm just going to express some concern that when it comes to persons who are disproportionately impacted by the campaign against marijuana planting, we have had an extraordinarily challenging time getting any data from policing districts related to the campaign against marijuana planting. It was essentially a federal program that was executed in partnership with local jurisdiction. So I guess I don't have objections to this, but I just have concern that, in any way, shape, or form, if it eliminated folks who suffered from campaign against marijuana planting, I think that would be an unintended consequence that I hope we would not be venturing into.
No, we discussed that.
Oh, good.
We did discuss that. So I think what we want to continue, and correct me if I'm wrong, the conversation is because we think there's another lane for that, right? Outside of social equity, there's possibly another lane, right? Because what you have is people that were absolutely hunted, right? But there's no record, right? There's no record federally, there's no record locally, absolutely. And then we have a group of people that's in prison that died, that have been hunted as well, but they got them. And we got that information, right? And so as we were thinking about this yesterday, we were like, how do we do this in an equitable fashion, right? And I think that that's the conversation we're going to have in our next meeting. It should be on our agenda. We wanted it on the next agenda. Is there a lane? Not that I don't think they belong in social equity, but I think there's a lane for those folks that were cannabis planting or cultivation that had the DEA take their parents away, that had trauma around planting a plant that now tons of people are making money on. And we see this happening with HHS. And we do think that that is a lane, but to try to compare the two lanes is so difficult. And we have 5 years in, and my personal opinion, and I'm not talking for anybody else on the committee, was that there's absolutely a lane for that. And we have to acknowledge that they have that trauma. And what that means is to give evidence, and also, not evidence, that's the wrong word, to give acknowledgement and to be respectful of that trauma that they endured and those things that happened to them in a lane that belongs directly to them. And that they get many, if not all, the similar things for social equity, but in this lane over here that we can actually run through, because to try to put them in one is to do a disservice to our legacy operators, to the people that are currently in prison, because of course HHS didn't do that, right? And I think that that's something that we as a council have to move quickly to get, because I know one of the biggest things in our call yesterday was people that were like, we're not going to get the grant funding. The grant funding is going to be gone by the time it gets to us. And I agree with them. That should not be the case. And we should kindly suggest, we should kindly suggest that there's a lane and that there's money for that lane and that they have access to those tax dollars like social equity does, because I don't want them to be left out. Again, and this is something I say all the time, I would not be here, most people would not be here if we didn't have our growers. There's not a single manufacturer that survives without a cultivator. And so if that's the case, and we're looking at Humboldt, Mendocino, the Emerald Triangle, people who were really hunted and things, their money was taken, their homes were taken, and there's no record. How do we honor their sacrifice?
Well, I sorry to interject, but we're talking about the language of the motion, and now I'm a little confused because you're talking about legacy, and I feel the language of the motion is applicable to social equity, correct? So,
I've misused the term legacy. I'm not talking about people in the underground. I'm saying people who are now have licenses and.
no, I understand, but I'm sorry, I just have to come back to the actual motion on the floor. The motion is to change the language for purpose of determining disproportionately impacted.
For the
The subcommittee recommends that DCC look at arrest data by police district rather than by census tract.
That
So,
stands, yes.
so there's two questions I have. The DCC, and does the DCC have their own definition of social equity, or is it up to the local jurisdiction?
There's, in regulations we have, it's defined like what a local jurisdiction.
Can you speak into the
equity?
mic?
Sorry. Right, see if I can get this. In regulation, yes, it does specify what a local equity person would be. And then there's criteria for meeting that, and that is in the regulation.
Right, but it's the local jurisdictions that determine those criteria
Correct.
as an equity applicant and verified. So I had to go through the San Francisco program to get verified, right? So I think, well, maybe the subcommittee, we take it back a step and first recommend that there be a statewide definition of a social equity criteria or eligibility. It could be a combination of a lot of the cities. I feel like some of our cities really did have a pretty good social equity criteria that you have to meet. But for reporting purposes, I would add the arrest data by police. And to Vice Chair Nevedal's point, rather than eliminating something, I would just add that to the reporting as well. That in addition to census tract reporting, we should also see the precinct reporting or the police district reporting, because then it'll also give us a comparison. And some of the people that would otherwise be left, stranded on the side of the road, like, oh no, look up there in Humboldt, you might not have the same number of arrests, but hey, this was disproportionately hitting these legacy growers. I would add, that's just my suggestion.
I mean, I think I understand why this is important too. I know that the census tract data,
Broad.
It's skewed and broad.
can be skewed and broad, but also it's, when we look at the campaign against marijuana planting, the impacts were so intense because if you were in one of those watersheds where camp happened every year, which I was, our watershed where I lived for a number of years was the first watershed that was camped every single year in Humboldt. So we knew the Monday after the first weekend in August, camp would full bore be in our neighborhood. And every single year. And then they almost always ended their reign of terror in our neighborhood. And there weren't arrests because it was open field search, right? So this is where we don't have the arrests or the police reporting data because there literally weren't arrests.
But therein lies the issue. There weren't arrests.
Yeah.
And so this issue is about people who were disproportionately impacted. And that's why we wanted to narrow that scope from a very broad perspective to police reporting district and arrest records, where people have been in prison for decades and communities were decimated by family members still in prison.
Yeah.
So
yeah.
that's where the issue of disproportionately, we understand that people were affected, no doubt. but we talk about disproportionate and people who have been incarcerated.
Yeah, and I think that's the distinguishing factor. We're trying to distinguish between impacted by the war on drugs and then disproportionately impacted by the war on drugs.
That's what the law says.
And you know, I believe that arrests, families being torn apart, is an indicator of a disproportionate impact. And so having the arrest data and using that as like, you know, the structure that we identify that around brings us closer to that disproportionate impact.
Well,
And it's not to negate
Yeah.
anybody's impact.
No, it is a disproportionate impact when you live in a militarized zone and you have Black Hawk helicopters with machine guns pointed at you and they're in your yard.
It's not disproportionate when that's in both communities, right? That's proportionate. The disproportion is when it goes a step further and people are incarcerated and taken out of their communities, taken away from their children.
I mean, to your point, I don't think anyone can argue the data, right? And the data shows that communities of color are incredibly disproportionately affected, and they're not in the census tract because most communities of color don't fill out the census. So that is very skewed in terms of data as well. And I'm with you. I strongly support this. I think you should probably add to Dr. Brown's point that the DCC includes, I would change instead of look at, includes arrest data by police reporting district. You can keep the census data in there so you can see how skewed it really is. I think it'll put it into
I
perspective.
have a question. Is this a motion that we need to take up as a full committee today, or is it something that can be?
I think it's here, and if you're ready for it, we can do it. If not, we don't have.
I know, well, I know we're gonna address this continually.
Okay.
So we're gonna come.
Go forth today, and we're going to continue the discussion.
Yeah.
In later subcommittee meetings.
Yeah, you can put more motions for next time. So if you want to put this motion, if you want to reword it, Dr. Brown. Or-
Is the purpose of the rewording to, like, why is it needed? I guess,
Data
are
accuracy.
people not getting funding because they're in the, what would be the correct police reporting district where they would qualify, but they're in this census tract where
Correct.
they don't,
Yes.
and that's why the change needs to happen.
That's
so that
correct.
They can actually qualify.
Yes.
And if that's the case, then putting it off another 3 months is probably a disservice.
Agreed.
But at the same time, I believe that if we were looking at just police reporting districts, it would eliminate the ability for cultivators who suffered under camp to be considered disproportionately impacted. That's my concern.
It could, but I think some of the disproportionality comes from person A is driving their car and they have a couple of marijuana seeds in their car and they go to prison. And person B has 500 plants growing in a field that get cut down and take away and adversely impact them financially and through other trauma, but doesn't end up in prison and
Doesn't have an arrest record.
doesn't have an arrest record,
Yeah.
doesn't come out of prison on parole trying to get a job and can't get a good job and goes, like, I think that's where some of the disproportionality comes from.
Yeah, I
So
know all of that.
both
Definitely.
are
can relate.
absolutely harms. Person A has a couple of marijuana seeds and is taken from their family and put in prison. Person B has hundreds of fully grown flowering plants and did not. And correct me if I'm wrong, but that's where I see the disproportionality and the need for something along those lines. Now, I don't mean to take away from the experience of
Yeah.
person B, but if it can be addressed, great. But if one size doesn't fit all, then maybe we work on one size fits one and we try to work on another size fits the other. And if we're ready today to move forward with person A, putting that off 3 months is not great. But keeping in mind that maybe in 3 months, we have that conversation about person B.
Well, and it seems like Member De La Rosa, Member Shockley, and Member Brown both are very clear about that. They're looking for that lane, but I think this one has priority. Yeah.
I did have a question though. I'm actually okay with adding it, right? Adding the language instead of removing it.
I agree.
So I like having all the data, we talk about the experience. Data is awesome. So
Yeah, I would recommend that the DCC include arrest data by police reporting districts as well as census tract, and then you have it to compare.
Yeah, I think it's important to switch it rather than add it.
Can you say why?
Yeah.
Sure, well, because the census data is too broad.
Okay.
And so it's too inclusive, and then it waters down the pool.
I think but that does get, that, I mean, obviously might just get dangerous on a case-to-case basis, but you are running the danger of someone who just lived on the wrong side of the street now in a different policing district not being eligible. I get what you mean. We have that in San Francisco. We have it everywhere where people take advantage of a social equity program, but exclusion of data is something I'm always a little worried about.
But I think that and correct me if I'm wrong here, but I think this really attempts to speak to folks who got entered into the criminal system, right? They were arrested, they have something on their record, they may have had to do time, and those challenges, they are additional impacts above and beyond being terrorized, right?
Yeah.
So I think that, I mean, that's what it sounds like.
Sure.
The goal is here is to ensure that the equity program is primarily assisting folks who really were deemed criminals because they have an arrest record because of something that's now legal. Am I following that correctly? Okay.
Member Paulson?
Just a question, is it, are the police reporting districts, is there reliable information? I mean, like data, I mean, I'm just worried about like, if an equity applicant just needs to get the data in order to substantiate the claims, is the police reporting district like actually reliable going back? Because I just know police data sometimes has a lot of holes in it, so.
Yeah. I'll give you a rap sheet pretty quickly. It's not that hard to get.
Produce their
Yeah.
arrest record.
They produce
Arrest
those,
Their-
yes.
Yeah, their arrest,
But
yes.
for the data point, the data would have to be pulled from the Department of Police Accountability. They're not just going to give it to you. That's sort of, in my experience, anything we've ever wanted in terms of data in San Francisco, we had to go through the Department of
And
Police
that's
Accountability.
required.
Yeah.
Is that complicated at all?
A little
Does that
bit.
Put in more roadblocks or anything, or?
It's a process.
It's a process.
It could complicate the applicant getting the information because I don't think that's publicly
No, I think
easily available.
there's 2 points here. One is the
Right.
verification of the applicant. The applicant can go in. I am one of those. I go in, get my federal arrest record, get my local arrest record, and submit it for my verification. But what Member Shockley's talking about is when the DCC evaluates the social equity program, what are the data sets that they want to use for that? And police arrest is much more accurate than census. We definitely both agree, less skewed. However, getting that data might be way more difficult than census tract data. So that's just something.
That would be the unintended consequence. I don't know how, not opposed to it, if the data can be gotten,
They would get it from the local jurisdictions because that's also a requirement. So the state would just require the local jurisdiction data to be uploaded.
Yeah.
In order to be a verified social equity applicant, and you're using arrest or conviction prior to 2016, you would have to submit that data.
You would have to look at when, not only where you were arrested, but where, and then what was the police beat or the police reporting district for that area at that time. But then how does that tell you how does the DCC know that RD qualified and this other one did?
So I think,
see what I'm-
I see. I think we're conflating a little bit.
Yeah.
Kind of like Jamalian was saying, there's the qualification for the individual, but then there's also the DCC using a criteria to determine what geographical areas qualify for those individuals. So the DCC will say, okay, this geographic area, individuals from this geographic area can qualify. And so this is addressing which geographic areas the DCC deems as disproportionately impacted. And
But it's more granular than census.
Yeah.
Like in the
Right.
city of LA, there's what, 87, 127 police reporting districts, right?
Yeah.
Very different arrest record rates for marijuana depending up a couple
Yeah.
of streets over, right?
Yes, but
and then census data, if I understand it correctly, it goes down to the zip code, right? And so you might have one community within a zip code that had high policing, but a majority of the community didn't have any policing.
Now everyone's
you know,
qualified.
No poverty, but everybody's qualified. So the idea is to bring it closer to those communities that actually were impacted.
Like in Los Angeles, you have a zip code that includes Griffith Park, the observatory, but but then there's a portion of that zip code that is, the majority of the zip code is affluent. But then, and you have a small portion of that zip code that is low income. Low income. But the folks who live in this huge affluent area would qualify as a social equity applicant.
Yeah, and I'm not opposed to the concept at all, but how do you determine that it's those police reporting districts that qualify versus the rest of the zip code? Like
They're more granular, right?
So
So the
who's
police,
making the determination that it's this side of the tracks and not that side of the tracks?
well, you'll see it by the police. That's why they want arrest records, right? If you have 3 stations in that affluent neighborhood, guess which one will have the most arrest records? Probably the one where around the low income neighborhood. So that's why it's more.
And I
more
guess
accurate.
the boundaries are more defined than the census. So the police reporting districts are a lot smaller and like,
So that's
familiar.
an affluent area, and the police stations that are in that affluent area have 80% less arrests than the low income area police reporting districts. That's how it's.
So they're going to look at this reporting district has a bunch of arrests for this thing and this one does
So
not.
they should
And
qualify
that
for more
qualifies, and
grant
that does
funding.
not.
They should have access. I mean, it also, I think, is to proportionally disperse grant funding, correct? Was that
And
one of
to
the?
your point about like, is all this information available? The places where the most arrests happen, it's available. The places where there are fewer arrests, it may be harder to find that information. Right. But the places where there are high concentrations, the data's there.
And I think that this is kind of aimed at clarifying the phase 1 portion of standing up an equity program, right? Where local jurisdictions utilize this definition to shape their assessment, right? Which they then put forward to the DCC to establish an equity program. And so then within that, there could be perhaps folks who are no longer in that policing district that might qualify once that program is stood up. But this is really about shaping the phase 1, the assessment component of the program. Am I correct? Okay,
Totally.
thank you.
Is there an understanding that when we use the term police reporting district, you're actually encompassing like the sheriff equivalent in an unincorporated county?
As
I'm
opposed
not
to law
sure.
enforcement,
As
as opposed to law enforcement,
right?
yeah, it makes
Because
sense.
Every law enforcement agency is going to have their own way of chopping up their
Yes.
their policing, right? But if you're in an unincorporated county, it's not going to be a police reporting district. It's going to be the sheriff's reporting district or whatever. So maybe.
One of the folks that live here is what about those small towns that don't have a police department? So we would have to think about how to solve for that. Yeah.
If you label it like a state law enforcement or local law enforcement.
All law enforcement.
Something along that lines. I don't know how you would I don't know how you say it federally, which
Right.
might not even be.
But the
Well,
DCC
what's-
include arrest data by local law enforcement.
Reporting.
Yeah.
Or-
District or.
Because like Mendocino, for example, has 2 incorporated areas, I think, right? It's a very large county, but there's only 2 police departments or 3 in the entire county. And it's a very small portion of the area of that county. Humboldt County has 5 local jurisdictions. So I'm sure there's counties that are more rural than either of the counties that I've mentioned that may only have 1 policing district for their area, and the rest of it is under the sheriff's purview. So I think it would have to encompass not only otherwise it will only be an urban program, right? It won't, and I don't know that that's necessarily the intention. I mean, maybe it is, but
sorry, there's unincorporated parts of LA that are probably, you know.
And you have CHP
right?
as
So,
well.
CHP,
So I think it's about local and state law enforcement. Those are the two that need to be included.
Thank you for submitting that, because I wasn't sure, but I do believe
Local and
it's,
state.
I don't
yeah.
have any problems with local and state.
Yeah, I think we should add local and state law enforcement.
Can we get a
data.
clarification on what police reporting districts includes
I would
currently?
maybe just keep it broader than that, rather than reporting district, just reporting from local and state law enforcement.
LA uses the term reporting district, but not every
Okay.
other law enforcement agency does. So
District.
that's one thing, as long as there's an understanding, a broader understanding of what we mean when we say reporting district, what we're really talking about is how does any given state
about
or local
agencies, right?
agency.
That's what I was saying. Could we get a clarification from DCC
So
if
perhaps
if
local and
that's
state is more
currently?
applicable
Right.
and more accurate.
And maybe
Local and
agencies
state,
instead of,
But how does the DCC currently use it? Like, do they take in data from local and state under this? They use census tract. That's right.
Yeah, that's a good idea.
Lost it.
state business matters. That's it.
This is your thing.
Yeah.
So why don't we amend it to say state and local
Law enforcement.
law enforcement,
Agencies or,
law enforcement agencies?
okay, so it would read, for the purposes of determining disproportionately impacted, the subcommittee recommends that the DCC include arrest data by local and state law enforcement agencies.
You're making the recommendation of the full committee, so it would be the committee.
Oh, okay. So we should reword that one more time. This is your motion, buddy.
No, thank you.
So
But yeah,
for
but that's
purposes
it.
of determining disproportionately impacted, the committee recommends that the DCC include arrest data by local and state law enforcement agencies rather than by census tract.
That sounds right.
Correct.
Do we have a second?
I second.
Thank you. Can we open for public comment, please?
Just a moment, let me get the amended verbiage so I can read it out first.
You want me to repeat it? Is that what you said?
That'd be great if you could just repeat it slowly and clearly. That'd be
For
great.
purposes of determining disproportionately impacted, the committee recommends that DCC include arrest data by local and state law enforcement agencies rather than by census tract.
All right, we have a motion on the recommendation on the floor, and we will open it up for public comment. Hannah Nelson, I've just sent you a request to unmute.
Held conversation. It's really important and excellent. I would like to suggest that if local and state law enforcement agency is the term rather than police, I would add in federal arrests in that region or whatever local region, because there certainly were a lot of federal arrests for during the war on drugs. And additionally, another alternative to consider is that policing is often almost a term of art, kind of like how Xerox stood for just all generic copiers. And so it may be an easier task to say any law enforcement agencies within the reporting areas. Anyway, just a consideration. Thank you.
Thank you. All right, Margro Advisors, I've just sent you a request to unmute.
Kelly Flores with Margaret Advisors. We'd like to ask the committee to recommend that the DCC work to ensure more equitable application of their criteria for rural and urban applicants. For example, the state's refusal to allow the use of PO box addresses for proof of residency demonstrates an inherent bias against rural applicants because many homestead farms do not receive U.S. Postal Service and only have access through their local post office. And we believe the process should allow the use of post office boxes and assessor parcel numbers on documents and allow a broader set of documents to be considered, including things like property tax bills, voter registrations, vehicle titles. Essentially, any documentation issued by a local, state, or federal agency should be allowed to be used as proof of residency. In addition, we're very concerned that this treatment has been creating an unnecessary divide between rural and urban victims of the war on drugs, and it's necessary to provide equal consideration for all those who have suffered. Now, we do appreciate that you're recognizing how the term police data may apply well to a city like Los Angeles, but it does not apply at all to rural communities such as Humboldt County. Instead, a place like Humboldt should use information like the 2008 Drug Enforcement Agency's map of activity for the campaign against marijuana planting. Those camp raids that occurred that year are a truer indicator of the areas and residents that were directly impacted by state and federal military operations. So we ask that you broaden your perspective when working to understand the impacts on rural communities.
30
which
seconds.
which were carried out and documented in a very different way than urban stop and frisk and other targeting activities. So we're asking the CAC to create an additional motion to recommend the DCC improve their efforts to ensure that all applicants are considered equally in receiving the support and relief that they rightfully deserve. Thank you.
Thank you. The floor is open for comments, both here in the hearing room and online. If anyone would like to comment. Janine, I've sent you a request to unmute.
Thank you, Janine Coleman, Executive Director of Origins Council. Really appreciate this conversation and the care being taken. We'd really like to acknowledge that the crux of the challenge facing both stakeholders and policymakers regarding social equity is the reality of having limited public resources to allocate to stakeholders who were disproportionately impacted by the war on drugs, and clarifying in policy what exactly disproportionate impact really means in order to support appropriate prioritization of these resources. So I really appreciate the work that the committee is doing around that and look forward to continuing that work. The other thing we feel compelled to address are the significant impacts to stakeholders when these programs roll out with an initial set of qualifying criteria, and then that criteria rolls back, narrowing benefits to stakeholders who have framed expectations or even invested in activities based on qualifying under the initial criteria. We're all working here to serve impacted communities through these programs and policies, and we must be very careful about compounding trauma for these impacted communities as we work to reform these policies and programs to ensure appropriate narrowing and prioritization of limited resources. These boundaries and criteria categories need to be carefully and accurately defined, and we want to ask the CAC and the Department of Cannabis Control to support a statewide, scientifically rigorous social equity needs assessment, and I'd like to suggest that the DCC Cannabis Research Grants could support this effort. Origins Council is grateful to the Hood Incubator, the Cannabis Equity Policy Council, for your partnership with us in this work, and many thanks to all the advocates, organizations, and policymakers working in this space. The work's challenging, but absolutely essential. Thank you, committee. Really appreciate the discussion.
Thank you. Jason Sharush, I just sent you a request to unmute.
Hello, everybody. RS Jason Sarouche, Policy Research Associate at the Public Health Institute. Thank you for this opportunity to speak. That last comment, really would like to echo what they said, really important points, but mainly I just would like to support, refining the state definition as the motion suggests for social equity criteria and identifying disproportionately impacted areas. So thank you.
Thank you. All right, this is last call for comment on this. Looks like comment is done.
Thank you. Can we get a vote on the motion?
All right. So I'm going to read this again before the vote. Okay. For purposes of disproportionately impacted, the CAC recommends that DCC look at arrest data by state and local law enforcement agencies rather than by census tract. So we can begin voting. Member Bauer? Member Dr. Brown? Member Brown? Member Christensen?
Aye.
Member De La Rosa? Member Frazier?
Aye.
Member Paulson?
Aye.
Member Shockley?
Aye.
Not member TP. Member Woolsey?
Aye.
Vice Chair Nevedall? And Chair Jamalian?
Aye.
All right, motion passed, or the
Thank you. moving on to agenda item. Oh, we're gonna take a break. Unless you guys want to just go through this, but I'm happy to take a 5-minute break if anybody needs to use the restroom, step up. All right, I'm done. Let's go move on. I'm with you. Let's move on to agenda item number 8, Public Health and Community Impact Subcommittee. We're gonna get an update from Member Christensen.
Hi, thanks everyone. Okay, so we had a pretty quick meeting yesterday where we had 2 presentations, one of which was actually provided by me. I gave an update on the progress from the last recommendation that came out of this committee from our June meeting, where we made the recommendation that CDPH work closely with DCC to collaborate on high potency THC and come up with both policy and prevention oriented responses. And so I provided an update essentially saying that, yes, we have been working together for ever since the recommendation has been made, and we've been meeting monthly. Some of the work that we have done since then is we have reviewed the 6 potential strategies that were proposed at the May subcommittee meeting that were then shared out in the June subcommittee meeting, which were taxing by THC content, focusing on THC purchase limits, THC potency caps on products, looking at age gating, looking at dosing and portion control, and then labeling and marketing. I want to be very clear that the recommendation and also the discussions that have followed have really been focused on recreational and not medicinal cannabis, and that was not clear in my presentation yesterday. So I'm saying this in part for the public and also for the committee members here today. The work that we've been doing is now aimed at reconvening this group of scientific experts later on this month, where we will be focusing intently on labeling and marketing. We selected labeling and marketing as being our priority approach right now because it is something that is feasible and it is actionable, and it reflects the urgency of this committee. So it is also something in which both the Department of Public Health and the Department of Cannabis Control has interest in and a degree of oversight over. So therefore, it is a bit more actionable than some of the other recommendations that were made by the experts in the prior meeting. We will be continuing to think through some of the potential opportunities and challenges of the 5 other suggested approaches. That said, labeling and marketing is going to be the focus for our future discussions. Let me look through my notes to make sure I'm not missing anything else. Oh, the other thing that we did was we reviewed our data dashboards, which reflected the California Department of Public Health's work in this area, trying to share out information on both poison control call visits through the California Poison Control Center, and also information from the California Healthy Kids Survey. It was a really lovely presentation provided by my colleague, Dr. Angela Krantz, who had shared out 2 of the dashboards that are available on the CDPH website. The intent is to expand these dashboards to include other information, including emergency department visits and helping to really document what the impact is of cannabis misuse or overuse, which I think is going to be helpful from a public health perspective and also helpful for those within the industry to understand the range of potential issues that can accompany cannabis use. There were comments from both the committee and also from the public that, and they were absolutely right, that the dashboards cannot differentiate at this point in time between licit and illicit use. Also cannot differentiate between the different types of cannabinoids. So there are some complexities and nuance that we need to take into account as we think through further displays of our data. And so we will be working closely with our data partners to think through some of the strategies and how we can improve that. There were no motions passed, so there is nothing for us to vote on here, but I'm interested on any comments or questions from the committee.
Can the databases differentiate between product type?
At this point in time, the data sets that we have are reliant entirely on self-report. So yes, to a degree, the quality of the data might not be what you'd want it to be.
And you said these are poison control phone calls mostly? These are just people calling, freaking out, pretty much.
Well, interestingly enough, yes, it is people calling, freaking out either about themselves or about their loved ones.
Sure.
Yeah.
And the emergency room data?
Emergency room data is considered administrative data, so CDPH does this for a number of the emergency room visits. We have an overdose data dashboard, for example, for our opioid-related
Sure.
overdoses.
You have one for alcohol poisoning?
You know, that would be interesting.
I bet you it's a lot higher. There's no limit on what you can distill or how much of it you can drink.
You know, I haven't done that analysis, but let me say the emergency department visit dashboard related to cannabis is not yet live. It's currently in the works. So if there's any suggestions from the committee on things that we should be taking into consideration, I'm all ears.
Yeah, I think having had an uncle who works at an ER and took an edible and freaked out, and he was going to go to his ER, and I was like, don't do it, because what are they going to give you? So I guess my question would be, would there be a way to track how they treated those visitors? Did they give them anything or just tell them to go home and listen to music or give them a saline bag or saline IV? I would be really interested because, I mean, when you get alcohol poisoning or when you get when you're overdosing on opioid, there's a remedy, right? It's Narcan pumping your stomach, whatever that may be. So we can't really treat something that doesn't have the side effects of alcohol or opioids the same. And I feel like this potency discussion is sort of reefer madness 2023. That's my opinion, especially when it comes to recreational use. I judge flower and hash cups. These guys can sit there and smoke more than I've ever seen. So I think the people that subject themselves to high potency products usually know themselves pretty well. And I feel like that's why we have safeguards like 10 milligram per piece on edibles for the kind of curious. They're not dabbing. So I guess I'm just kind of wondering where the health committee subcommittees fear or where their concern is stemming from with high potency products. That's really what, and why it's being treated similar to an opioid or alcohol. Because if we're running poison control and emergency room visits, we should also talk about the effects of what is the worst effect that cannabis can have on you physically.
Yeah, I appreciate that. I do want to separate out the concepts of high potency cannabis with the data dashboards, though. The two conversations were not intended to be connected. So the high potency discussion was specifically in response to updating the subcommittee on the progress that we have made since the June recommendation. So essentially wanting to demonstrate and be transparent about the progress that we've made since then. The dashboards, however, they are meant to be neutral. We are providing data to the public, and I really think it would be of interest of all members of the committee to just take a look at it, because you may surprise yourself in terms of what you think that we are presenting. I will say emergency department visits and their severity are going to vary dramatically based off of the population. And one of the things that we are very concerned about is underage unintentional use. And to a certain extent, there's people who are of age where they are able to use, and they are also unintentionally using, and therefore they fall also into this category where they do need help and support.
Sure.
So I guess just want to be careful not to try to confabulate those two.
Oh, I didn't realize they were separate.
Yeah.
But I mean, I will look at the dashboard, be happy to do it. But I think as soon as you have some verbiage like poison control calls, it's a very negative.
The biggest finding on the poison control call dashboard really is that there are increasing numbers of poisonings in the under 5-year-olds. And this is a finding that is reflected not just in California. We see it in many states that have legalized either medicinal or recreational marijuana. And it's because edibles are appealing in a fashion that is
Sure.
appealing also to the under 5s. And it's way too easy to eat multiples. So then it becomes a matter of thinking about what are the recommendations that we can make for consumers to think about safe storage.
And I think that's more of a consumer safety issue because the packaging as it stands, especially if it's multiple use, has to be child resistant, which we all know doesn't work with children most times, right? But is there, what kind of packaging ideas did you guys have? What would you want to add to labeling and packaging?
We did not talk about
Oh,
that.
that's just what you're focusing on, strategy, like labeling and packaging?
Yeah, the first presentation that I gave was on high potency the high potency discussion. And we'll be meeting later on this month to talk about the labeling and marketing, not the packaging.
Because that's where you think, that's where you have the most impact.
Absolutely.
Awesome. All right, thank you.
I have a question about the high potency. Have you reached out to any cannabis medical doctors who have practices and who are very well versed in the endocannabinoid system? Are you reaching out to talk to them about high potency cannabis?
You know, it's interesting. That was also a recommendation that came through on the subcommittee meeting as well. So that's something that I'm going to loop back with the team about.
There's the Cannabis Clinician Society out of UCLA, and they're doing some real cutting edge research. I was just at a conference they had last week, and they addressed the issue of high potency and its impacts on, of course, youth and then adults. So I think it's really interesting and important to get their input and just to guide your conversation more.
Any other comments? Thank you, Member Christensen. Do we take public comment for this point if we don't have something to vote on? Can we open for public comment? Almost went through it without having to ask.
Yes, we'll open public comment for item number 8. So public comment is now open for agenda item number 8. Members of the public would like to make a comment, please raise your hand. At this time, I don't see any commenters for agenda item number 8. Would you like to close public comment?
Yes, please. We'll close public comment and move on to agenda item number 9.
One moment. Yes. Judy, I've sent you a request to unmute.
Just respectfully suggest that perhaps the next time the CAC meets, that we rotate the order of the subcommittees reporting. Some of us have been waiting for this particular subcommittee since 10 o'clock this morning and had to move on. I work at a school site, and I've been trying to track my opportunity to share some thoughts, and it's been difficult to have it be now 5 hours since we started this meeting. No disrespect meant. I'm just pointing out that most of us are at a work site, especially those of us who work on behalf of young people. And so I do want to reiterate that the packaging that is so attractive to children contribute to their use. It isn't simply that they saw something and ripped it open and used it. It's that it looked like something familiar to them, either chips or cookies or a drink in the case of several of them. And that we did have on the call pediatricians at some of the children's hospitals speaking about how serious were the consequences for these children, that they had to be incubated or in intensive care. So it wasn't a situation where they were just sent home because they were sleepy or something. So I don't want to dismiss for our families who've had this experience the seriousness when it's young children who are involved.
Thank you. Sarah Armstrong, I've sent you a request to unmute. You're unmuted.
All right. I'm Sarah Armstrong. I represent the interests of Americans for Safe Access in Los Angeles and Ventura counties. We're coming up on the end of the legislative season, and depending on what bills pass, the next step will be to promulgate regulations and take other administrative steps. This is where this August body can be so helpful, because you know better than anyone what's going to hurt and what's going to help in terms of regulations. I would ask that once we know what's passed, that the appropriate members of the committee begin thinking and talking about what regulations might look like and how they might be as helpful as possible, both to the cannabis community and to the regulators. Without your guidance, we may end up in a very dark place because, of course, you have a variety of influences and situations impacting these regulations. So if the body could begin to think about dividing themselves up by their expertise to talk about regulations, it would be very much appreciated. Thank you for your time.
Thank you. All right, Jason, I've sent you a request to unmute.
Hi, RS Jason Sarouche, Policy Research Associate at the Public Health Institute. I just want to make a comment about one of the committee members, I don't know who it was, said the Canna Curious aren't dabbing. I actually think while they might not be dabbing, vape pens are actually probably a much easier way to start consuming cannabis than smoking a bowl or a joint, just given the fact that it doesn't smell as much, it's not as obvious to people, and it's really easy to carry around and do. So that comment that, oh, the people who are just starting out aren't using these products that can cause intoxication, cause heavy intoxication. I personally freaked out many times when consuming an extract. And yeah, it's not life-threatening getting too high, but to diminish it and to say that it's meaningless and these are just people freaking out, calling the Poison Control Center, it really minimizes the fact that to that individual, that is a really serious event in that moment. Not to say, again, cannabinoids should not be treated like opioids should, but both endogenous cannabinoids and endogenous opioids exist. Both cannabinoids from plants and opioids from plants affect our bodies in different ways. So generalizing how people will respond to exogenous cannabinoids is extremely narrow-minded. And that is not how you should be looking at the way wide access to cannabis affects the public and affects public health. Okay, because there are people who have had serious negative effects from cannabinoids. Mind you, again, it's not trying to compare it to opioids or to alcohol. When you say a lot more people die from alcohol and opioids,
30 seconds.
You're absolutely right, but you can't minimize it and diminish it because in your experience, you're around people who can consume copious amounts of cannabinoids. That's not the way to go about it. Thank you for your time.
Thank you. Dr. Trina Hazza, I've just sent you a request to unmute.
Guys hear me okay?
Yes.
Okay, thank you. So my name is Dr. Trina Hazza. I am the president and co-founder of the Veterinary Cannabis Society. I actually had the pleasure of meeting with Dr. Jacqueline Campion this weekend at the Society of Cannabis Clinicians Cannabis Conference. And I chatted a little bit with her. She was wonderful. And one of the things that we played a fairly big role in was helping get this bill passed, 1885, that allowed veterinarians to recommend cannabis. We are a nonprofit, a 501c3 nonprofit, product neutral organization, and we believe in the safe use of cannabis for pets. And so what I'd like to do is ask that we have a future agenda item in the next meeting where it would be for the animal product standards for cannabis required under the AB 1885 regulations to be promulgated before July 1st, 2025. And so we'd like that item to be added to your next meeting in December so we can discuss with you all our thoughts and the importance of veterinarians, and specifically a product neutral nonprofit organization having a role. So we'd like to have that item added in. If that's what I would like to say.
Thank you.
Thank you.
Let's keep the comments to the actual agenda items, please.
Michael Katz, just sent you a request to unmute.
My name is Michael Katz, Executive Director for the Mendocino Cannabis Alliance. And related to this conversation, I think it's just important to note that talking about these various health and safety recommendations, that this is the regulated cannabis industry, which is already employing some of the most stringent product safety regulations in the history of the world for a product that does not cause death from overdose, as someone from the Public Health Institute just admitted. And it's not to diminish the experience of people who consume too much, but it's to create some perspective on that. And in relationship to how any further regulations on potency or labeling will not at all impact unregulated cannabis, which is what more than 2/3 of the purchases are happening in the state, are happening on the unregulated market. So I encourage this committee to not make any recommendations that will further harm and inhibit the regulated market that is already so regulated, while ignoring the fact that there's no way to identify what these numbers represent as far as regulated versus unregulated products, and the harm that will come to the regulated industry. And I encourage you to keep those things in mind as you're making your recommendations today. Thank you very much.
Thank you.
Thank you. Last call for comment on agenda item number 8. Okay, agenda number 8 is closed.
Thank you. With that, we move on to agenda item number 9. Future agenda items. Our meeting is set for December. Will include reports and recommendations from any subcommittee meetings that meet between now and then. I'll also work with the DCC to build the December agenda based on some of the evolving conversations and upcoming activities, including the annual report to the legislature. And if you have anything that you think should be considered for that agenda, now is a good time to go on record. So the floor is open.
We talked about it a bit last time, but anything from the DCC related to where the current recommendations have landed, and if there's other information that the department is looking for to seek out to make better decisions. Not saying they should have it all done and entered, but if they have a conversation, they want more information, or for us to host on our subcommittees, opportunity to get more information, it'd be helpful for us to gear where we're going with our subcommittee.
Like an update and a pressing matters.
Yeah, just kind
timeline.
of what do you want to talk about, or what do you want to hear, so we can talk about things relevant to what they're dealing with.
Any other suggestions, input,
About hemp.
or by?
We're keeping hemp out of
Um,
conversations.
I'll talk to the DCC about it, but I know that the next one is pretty packed, right? Our next schedule in terms of,
I don't think the DCC regulates hemp.
well, I know that, but I think the point is processing hemp in licensed facilities. Is that what you're referring to?
I mean, there's a lot of,
There's a lot of sort of cross points and touch points.
yeah, how hemp products or byproducts or derivatives of hemp are flowing also into
Sure.
the cannabis industry.
I know that in San Francisco, we have a pretty robust conversation with the Department of Health about this. I think, if I'm not wrong, it does fall under the Department of Health because it's not regulated by the DCC.
Yeah.
So likely not to be on the next agenda.
Okay.
We have a date. What'd you say? Oh, the date for the
Date
December
for the
meeting.
next meeting, I don't think we've set that yet. We usually do a poll, right, and see when everybody can attend to have quorum.
Full committee. Set for December 7th. Thank you.
December 7th.
Second or second?
7th. Can we open up for public comment, please?
All right, we are opening up agenda item number 9 for public comment, and going to kick it off with Judy. I'm sending you a request to unmute. There you go.
Hello. A press release that's making the rounds among school districts today has to do with the information that's coming out from Alameda County, working with the school district there. I'm speaking now to future agenda items because I realize that you wanted to take the discussion of hemp out of your conversation, but there's a nexus here, especially in the educational community. And they are talking about a manufacturer who was manufacturing flavored tobacco vapes and also hemp vapes that claim and seem to be tested to be true THC in them as well, and selling them out of their manufacturing site and online without any respect to the age of those buying. And we're beginning to see more and more of that co-joined activity. So my point is, as long as we see a mixing among manufacturers of those things that could be considered legal products that a permitted pot shop might offer, and those things that might be considered illegal because the hemp is manufactured and not from the source, that makes it illegal from a federal point of view. It might be something to consider for the December agenda, because I think we're going to see more of this.
Thank you.
Thank you.
Josh, I'm sending you a request to unmute.
I commented one comment is probably not noticeably about the hemp industry or product making it into the legal market of the cannabis industry. Currently, there is a CBD to Delta-9 THC conversion being done across the United States. So they take CBD isolate, make Delta-9 THC, and there is a way to determine which ones are and aren't. And in the state of California, there are products on the shelf of the legal cannabis industries that are CBD to Delta-9 conversions. I would like just it known by the board that this is something that should be looked at currently. The reason they're doing it is because the price of the manufacturing of CBD Delta-9 is a lot cheaper than extraction. It can be found in edibles, vape pens, and other things on the products on the shelves today in many states on the legal cannabis market, as well as the hemp market. These are synthetically derived cannabinoids, not naturally produced. So there's a lot of questions on safety and any kind of regulation on it. I just wanted to point that out. Thank you.
Thank you. Are there any other comments on agenda item number 9, future agenda items? All right.
That concludes agenda item number 9, and the meeting's adjourned. Thank you.
Thank you.